May I please, Lordship? Lordship,
Yes.
I beg to mention item number 21, Your Lordship.
Hmm?
Item 21, Your Lordship. Lordship, here my senior has some personal difficulties with it. So I beg
20?
21, Your Lordship.
Yes.
So I beg that this matter may come up after 1 week, Your Lordship.
Why?
My senior has some personal difficulties today, Your Lordship.
It's for?
I'm for the
Washing?
petitioner. No. It's for clubbing of 3 FIRs.
Huh?
There are 3 FIRs in petition. I'm seeking clubbing of the subsequent 2 FIRs with the first FIR.
In respect to the same cause of action.
That's my contention.
Lordship, my senior has some personal difficulties today, Your Lordship. So,
Leave it tomorrow.
then on Thursday, Your Lordship.
Huh?
After a week, Lordship.
Why? How can there be a personal difficulty for so many days?
Lordship,
Wednesday, Thursday.
Lordship. Apply tomorrow.
May I please, Your Lordship? Lord, I like to mention item number 20 with the consent of the other sides, my lord.
Yes.
My lord, I pray for an adjournment, my lord, for the week, my lord.
Why?
My lord, I could not proceed to Kohima because of personal
You can do it
difficulty,
from there.
my lord.
You can do it from there. You are clear and audible.
It's there, but I thought of going there. I could not go and
Don't promote yourself coming to Kohima. The roads are bad now. Do it from there.
Weather is good, my lord.
We'll do it
Weather
there.
is good. Weather is good, my lord.
Weather is good, but the time you didn't like to come to enjoy the weather. Sir, can't be a ground for achievement. Nowadays with video conferencing and that too on the ground that you are not, we can hear you clear and audible.
That's there. But the local council also, in fact, my lord, sees out of station. That is another ground, my lord. Any day in the next week, or my lord, after the vacation, my lord, convenient to report.
Story of the juniors with you. They can very well help you there.
That be my lord, the next week, or my lord, any day after the my lord, this summer vacation
For quashing.
for caution. My lord.
What is there to caution a fire?
It's an out and out civil dispute, my lord.
So we'll quash it then. Then out loud you say we trust you. We'll quash it. What is it?
Can be in the next week, any day, or my lord, after the vacation, my lord, any convenient day to the
Thursday. List the matter on Thursday. On that day, you either do it from there. We are very clear on there. The system out here, the video conferencing system in Kohima is the worst. We'll have it on Thursday. You need
My
to
lord, Thursday can go. Lordship. Thursday.
May I please, Your Lordship?
Okay.
In item number 15, Lordship. In this matter, service report is awaited. Lordship, may kindly fix the matter on 15th of July, Lordship.
15th?
Yes.
Yes. We'll see when the matters come. It's for orders.
Interim. My lord, the interim to be continued, my lord, in item number 20.
Item number 20, interim order shall pass earlier, shall continue till the next date. If the any interim order, if any, shall continue till the next date. Yes.
For admission, item number 1.
Yes, you have not been able to settle it.
No.
Is that the same matter?
Yes, ma'am.
This is what a matter pertains to what?
But my lord, there's an award, my lord. The expert award, not we filed for an execution enforcement, my lord, before the principal district judge Kohima, my lord. And because of this national justice and other melodies appointment of arbitrator, my lord, that two ground, my lord, then they dismiss the award, my lord. The London district judge, my lord. But in the under 36 minutes, but they have not filed any petition under 34 minutes. They have never filed, and they raised the oral objection when execution there is a execution proceeding here. Yes, my lord.
The award was in your favor.
Yes, my lord.
Then,
We filed for execution before principal.
then
It was dismissed. The
you
hospital
filed for execution under 36.
36, my lord.
Did they go under 34?
Yes, my lord. But they have not filed any petition, my lord.
How did they go?
My lord.
How did they go to 34?
My lord, if my lord is award is my lord, if any.
Let's see the order.
Yes, my lord. Page 74, my lord. My lord, on page 77, my lord, the observation of the view of the court is there. Page 77.
Mr. Longso, you have not challenged it under 34?
My lord, this is no award, my lord.
No, whatever may be.
Simply put,
Whatever may be, don't.
my lord, no. The law is very specific that it has to be by reference by the civil judge, senior district judge, or high court or supreme court.
That is
Without that,
that is absolutely correct. But you see, an award can be set aside within the purview of what is there in.
my lord, what I'm saying is that this is without any authority. It is outside the law.
Whatever may be.
No, my lord. What I'm saying is this.
Whatever may be. Kindly see section 34.
My lord, yes, I understood. But what about the court? Only the court can give authority for arbitration proceeding. There was no application for arbitration proceeding. Even in this court, now arbitration application is filed. Even today. You've never filed a application for arbitration in any court of the law.
Now tell me, Mr. Longso, have you received a copy of the award?
No,
You're sure?
No.
You filed an affidavit.
no.
Have the receipt?
My lord, what I'm saying is,
No,
I
why-
find the law.
No, Mr. Longso, kindly appreciate. The law is very clear. I'm trying to help you out. The law is very clear. That
This is
unless
not my petition, my lord. This is your petition.
understood, otherwise I have to allow this petition. I'm asking you therefore one thing. Section 31(5) and section 32 categorically mentions that the award which is being passed has to be intimated to you, delivered to you.
My lord, the first question is, either an arbitration can be proceeded in my own,
Therefore, you have the provision of
Yes.
section 34.
my lord.
34 says that if the appointment has not been done properly, you are to challenge it for setting aside.
When the order itself is a nullity. Anybody passing an order will rush to the court. If there is yes, I understand. If it is as per the provision of law, yes, certainly 34 will be the first step.
Then
But there was no proceeding in the, as per the law.
where the
So
award,
there is no proceeding.
why haven't you not filed the award?
Right.
Now, whether this award was served upon him,
My lord, yes, my lord.
how do you say so?
The paper publication also there, my lord.
Huh?
Paper publication also there, my lord.
Paper publication is not an award.
My lord, that's my instruction, my lord. Right now I have that instruction. And this all, that instruction right now I have not.
That is the most important
Yes,
thing.
Uh,
Because if you see the various judgments of the Supreme Court categorically says
understand.
that proceedings of arbitration would come to an end only upon delivery in terms with 31(5).
Yes, my lord.
Now, has this award been given? Understand? If it is not given,
Yes.
then the proceedings on arbitration is not in.
Yes, my lord. But that has to also be under section 34, my lord.
No, if they, no, not necessary. When do you challenge under 34? You challenge when the proceedings has come to an end.
Yes, my lord.
Now, if the, you kindly see section 31(5).
After the arbitral award is made, his signed copy shall be delivered to each party.
So,
Yes.
for this to come to an end, because the Supreme Court categorically says that from that time, the period will start.
Yes.
So, if he has not received a copy of the award from the arbitrator,
Understand.
you can't go for enforcement because the termination under 32 would only happen at a time when it has been delivered in terms with section 31(5) read with section 3(2).
But yes, that is true, my lord. But here, my lord, in this question never is raised before when proceeding under 36 is there, my lord, before the district court, my lord. There only this only there it is mentioned, my lord. They have not filed any written objection also, my lord. They all these things they never raised before. It's only there the sole arbitrator was one by director of border and not under the provision of law. And at no point of time the suit was instituted by decree holders reference so and so. It is page 75. The since court had never referred arbitrator so and so claimed to be sole arbitrator, the so-called decree has not been produced. Produced the arbitration agreement before the court and so and so. Their judgments so and so jurisdiction. These are the their question raised under page 75, my lord. This is oral question, my lord.
Who will appoint?
My lord, as per of this clause 37, my lord, of the agreement, my lord, we appointed, my lord, the engineer, my lord. It's
Of an engineer officer
engineer officer, my
to
lord.
be appointed by the authority.
Yes,
Because this was prior to 2015.
Yes, my lord. Yes,
So under such circumstances, the amendment which was brought
yes, my lord.
in 2015 would not apply.
Yes, my lord. Everything is before 2014, my lord.
No, therefore,
Yes.
that is another thing. But the most important thing is this,
I understand, my lord.
that you can only go for execution
Yes,
at the time if
yes.
it is delivered.
Yes, madam. That instruction I have to take, madam. And so, but my lord, in present petition, they have not filed any objection, madam. And in when proceeding 36, they are not filed any objection regarding that point, madam. This court may raise this, madam. That one never raised, madam. Only this oral submission is recorded, my lord. Only two things, my lord. When the learned court below this rejected, my lord, on a national justice and the appointment of arbitrator, my lord. This page, my lord, start from page 77, my lord. Paragraph 5, my lord. 77, paragraph 5. Court has considered submission parties record, my lord, regarding appointment of arbitrator and national justice, my lord. Regarding the appointment of arbitrator, my lord, this court considered maintaining present application, my lord, and that application, my lord, and another, my lord, the national justice, no violation of national justice, my lord. Page 77, 78.
And they did not file an objection there.
No, my lord, no, here also not, my lord.
My lord, this
Yes.
is a question, pure question of law. See,
Mr. Longsir,
section
Mr.
2,
Longsir.
what does it say?
No, whatever may be. You want to do anything, you have to do something. You cannot, because the Supreme Court, not only Supreme Court, the Act, Section 34 is clear. You are to challenge it under 34.
Well,
Now, the period is long over. So long over, only way out is 31.5 read with 33.2. This is the only way out, and 32. You need, I can help you with 2, 3
My lord,
things which are there, which help.
first thing have to be
Otherwise, there's
considered.
no case. You don't have a case. We'll allow his petition. What do you want? If you don't raise that issue, that you have not received a copy of it, the court could not have gone behind the decree. In fact, let us assume you have a case. Therefore, you have to say that the award is a nullity.
Yes, that is the
How do you do it?
uh,
No, Mr. Longsa, how do you do it?
Section 2.
Section 2. This will be done under 36 of the Arbitration and Conciliation Act. Now you see, this was at a time when 2015 amendment did not come in.
Yes.
So therefore, the various judgments of the Supreme Court in the case of Perkins and all could not apply.
Yes.
And the only way out for you is under 31.5 read with section 3.2 that you have not received. And as such, there is no termination of the arbitration proceedings. And if there is no termination, he cannot go for execution. That is the only way out. Or I would have understood making it an executing court. It is an executing court. You have to file an application under 47 of the CPC saying that the award is a nullity. But without doing that, can't do that. The court completely made a mistake.
And my lord, this judgment, my lord, says, my lord, if executing court prove that this objection, then it would be travel beyond the degree which is not person.
No. Mr. the law is very clear on this. There's no quarrel with that.
Another judgment is there, my lord, the Allahabad High
The
Court.
law is, you don't need the Allahabad High Court. There are many judgments of the court.
Regarding
The
my lord,
law is very clear. But Mr. Longshar, unless you help yourself, I can't help you further. What do you want to do? Otherwise, this is a case for allowing it.
and my lord, so far it is not this award, arbitration award is not a decree, my lord. My lord. As
What?
well, yes, my lord. There is a judgment.
Yes,
my lord.
that is what
Yes, my lord.
is
This
saying.
these are a judgment, my lord. There is, my lord,
Which court did they?
my lord, this, my lordship,
Which court?
the Allahabad High Court, my lord.
Section 36 makes it clear.
Yes, my lord. Yes, my lord.
You don't require that to the Allahabad High Court for that.
Yes.
Section 36 makes it clear that it would be a decree.
In the same.
Only thing difference is,
Yes.
only thing difference is which have been observed by the Supreme Court in 2 judgments to that effect, that it cannot be treated as if any other,
Yes.
all the effects of a decree would be there.
Yes.
But otherwise, it is to be treated as a decree.
Yes, my lord. Yes.
The difference is out there with section 17 earlier,
Yes.
or section 40 of the arbitration in this stage, that you don't need to make it a rule of the court. It becomes a decree on itself.
Yes, my lord.
Then
But 47 not lies, my lord.
why?
My lord, this, it is, I have the counter this judgment. my lord.
47, you can very well, the executing court, when the executing court is taking up the matter, why not 47 will lie? Because what is 47? 47 says for the execution, discharge and satisfaction, it is the executing court. And doesn't it, section 36 categorically say that it will be put as if like a decree before the court for executing? What is section 36? Read it.
Section 36, my lord, is the time of making application to set aside the arbitral award under section 34 has expired. Then, subject to provision of this subsection 2, such award shall be enforced in accordance with the provision of the Code of Civil
That's
Procedure
what?
in the same manner as if it were
A decree of the court.
That court. Same.
Therefore,
Yes,
why do you need the Allahabad High Court for that? The law is very clear on that.
Yes, my lord.
It will be treated like a decree of the court.
My lord, my lord, the Allahabad High Court says the court has taken.
Not necessary, Mr. Mehdi. Don't come up with that judgment. This court doesn't want to express any opinion on that Allahabad High Court judgment. But whatever may be, It is a decree of the court, so it will be done as per the CPC. And if it's CPC is there, why not 47? Because 47 gives the power to the executing court to do for the discharge, satisfaction, and execution of the decree. So this is the power. Now he has to come up before the court that you can't go for execution because it's a nullity. He has not done that.
Yes.
How can I help? This is a case of allowing. What do you want to say, Mr. Longsword? Should I allow it?
Let me assert
Allow it.
about that. That's a question of fact.
We allow it. I allow it. You do whatever you want.
No,
You file whatever.
My prayer is that I may be allowed to file to that extent whether the party of
You
this.
therefore have to file it before that court.
Malad,
No, not here. This is under 227.
227.
Because here, question filing doesn't arise. You are to go to that court.
Malad, I can file a truce.
Huh?
Truce.
You have to file there.
Malad, before the revisional law, before the appellate, truce objection can be filed.
You can't file here. This is not an appellate court. This is a 227. We are to only see as to whether the court was wrong. If you want to file anything, you file there. I give you the liberty. Go and file it. But not here.
Malad, one first issue have to be decided. Use what my learned friend has read out. It says subject to Section 2 of the Arbitration Act. Section 2
Criminal arbitration.
E is very clear. Court means the principal civil court in original jurisdiction. After original jurisdiction in a district and includes High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the question, forming the subject matter of the arbitration if the same had been the subject matter of a suit, but does not include any civil court of a grade inferior to such principal court. So first is, it has to be a subject matter before the principal civil court.
It is
or
here the
is-
principal district judge who have taken it. The case has been taken up
No,
by the
there is
principal.
no suit.
Not
The principal,
necessarily. Mr. Longsword, these are things which are not necessary. Section 2E confers a jurisdiction under to the principal civil court. And if you see the principal civil court, the definition out there would mean the district judge. Or if any power has been given, delegated by the district judge to any other court. Now, in places out there in Delhi, Madras, Punjab and Haryana High Court, Calcutta, Bombay, they have the original jurisdiction. So therefore, the High Court would be the jurisdiction.
here also we have the original
We
jurisdiction.
don't have.
No,
No.
there is an application before this honorable court. Arbitration application.
A petition, this court doesn't have the original jurisdiction.
My lord,
This court, therefore, you see section 11. The section 11 says it is not to the court. It is to the Chief Justice. It is office.
my lord, there is a arbitration application pending before this honorable court.
Which one?
I may be allowed to appraise your lordship because that is one of my learned colleagues who have filed it. And it is before this honorable court.
Which petition?
Arbitration application.
Under?
Maybe an appointment of arbitrator, maybe.
That is what.
Therefore, Mr. Longsword, I am saying for appointment of our arbitrator, kindly see section 11. It does not say. It says to the High Court. See section 11. It says to the High Court. And at the time when this happened, it was to the court of it was to the Chief Justice. Kindly see section 11. That is why it is being there. Appointment of arbitrator so and so. The Supreme Court or the High Court shall have the power to designate arbitral tribunals. So it is to the Supreme Court or the High Court only section 11. They use it. But court would otherwise mean principal civil court. And earlier it was the Chief Justice. At that point of time when your dispute arose, that was the Chief Justice. Therefore, recently in 2019, they amended it and made the High Court or the Supreme Court. Because then what happens earlier, you may have seen, if you go to the principal here, matters may not be much. But if you go to the principal seat, earlier it was only the Chief Justice who was taking it. Now it is being given to a particular court, any court of the High Court. So what to do?
My lord, I may be allowed to take the instruction from a client,
For what?
as your lordship has pointed out.
That is what you pointed out before that court. I can't do anything. What happens if I allow his petition? The proceedings which have been there, the execution proceedings revives. Okay? Now, in that execution proceedings, you file 47. Take all grounds which you feel like and argue them. Shalom. The instant application under Article 227 of the Constitution has been filed challenging the order dated 14/7/2022, passed in execution case number 1/2015, whereby the learned Principal District Judge Kohima, Nagaland, had dismissed the said execution application, holding that the award, that the holding that
My
the
lord,
award, ex parte
I
award,
may be allowed to interrupt, my lord. There is no continuation application before your lordship.
huh?
Continuation application is not before your lordship.
Confirmation of
Condonation.
Continuation application.
this is
No.
under 227. Mr. Longsir, this
Yes.
is 227. 227 has no the limits. There is no limitation.
This is a civil court proceeding.
So 227 lies. You need a judgment, I can give it to you. But the Supreme Court says 227, there is no jurisdiction.
This honorable court has clearly given in the first motion, at the time of motion, to file a continuation application.
There is no
This-
condemnation application. The
this
court
is-
said explain the delay,
This is,
explain the leakage. Yes.
yes, that is the court order, not my submission.
You see, when the matter came up before me, nobody put that question. I put that question on 5/12/2023. I said that Section 34 for setting aside the so and so which is not permissible without an award, this is his contention. Then has been no challenge as why after a lapse of 22/11/2023 this application was filed. So I asked him to file an additional affidavit explaining the delay and latches. So accordingly he has filed. So matter is, and there is no, you see, 227 there is no limitation.
Then it will be against your own lordship direction in order.
Hmm?
In the first place, it was before my entry.
Yes, without your entry also I have put that question.
Yes, that is your lordship's order, own order.
No, order was there, therefore they filed the application. Not the application, I didn't ask
It's
him.
not a continuation application. No.
No, Mr. Longsir, the question of condonation section, I can't bring in section 5 to 227 proceedings. Section 5 is only applicable in its respect to a civil proceedings. This is not a civil proceeding, this is a constitutional provision. Can there be a question of a section 5 application in a 226?
My lord, in the first place, that is the order of this court.
So they filed it. They filed the additional affidavit explaining it.
It's not an explanation. It's not a prayer for continuation.
There's no
It's just
condonation.
aside.
Mr. Longsir, the question of condonation does not arise. It's the question this court is satisfied with the doctrine, with the latches, or have they explained the latches? There's many judgments of the Supreme Court which categorically says that 227 there is no there. You want one, I can give it to you for future reference, not here. Anyway, let me dictate. What did you write?
Last investigation is number 1 of 2015, whereby the Resident District Judge Kohima had dismissed the same efficiency accusation to be that ex parte.
Holding that the ex parte award was not executed. First of all, I've heard Mr. S.K. Mehdi, the learned counsel, appearing on behalf of the petitioner, and Mr. I. Longshore, the learned counsel, appearing on behalf of the respondents. From the materials on record, one aspect is very clear, that there is an arbitration award passed on 1/9/2014. First, it is also an admitted fact that there is no application filed under Section 34 of the Arbitration and Conciliation Act 1996, for short, the Act of 1996, for setting aside the arbitral award. There is also no application filed by the respondent herein before the Principal District Judge Kohima, Nagaland, that the award cannot be, that the award is a nullity. In spite of that, the learned court of the Principal District Judge Kohima, that is the learned court below, for short, the learned court below, have held that the execution proceedings cannot be maintained on the ground that the award dated 1/9/2014 is not executable. First, at this stage, if this court, give me the arbitration. There you go. At this stage, if this court takes note of that Section 34 of the Act of 1996, it stipulates that a remedy is available to a party who is aggrieved with an award by filing an application for setting aside the award. It is no longer res intriga that an award can be set aside only on the grounds which have been enumerated in Section 34 of the Act of 1996. If this court takes note of the award, the impugned order, it would be seen that the learned executing court, learned court below, had held that the award is not executable in as much as the appointment of the arbitrator was not in accordance with law. This court finds it very pertinent at this stage to observe that section 2A stipulates the section 34 2A stipulates this to be a ground for setting aside the award. However, without filing of an application for setting aside the award, the learned executing court could not have held that the execution, that the award was not executable. During the course of the hearing, Mr. I. Longcha submitted that the arbitration proceedings had not terminated in terms with section 32 of the Act of 1996. Inasmuch as without delivery of the award in terms with section 31(5), the award cannot, the arbitration proceedings cannot be said to be terminated, and without the arbitration proceedings not terminated, the award so passed cannot be put to execution. This court is of the opinion that if such is a plea, the respondent ought to have raised such issue before the learned executing court. And this aspect of the matter cannot be dealt with by this court. Under such circumstances, this court sets aside the order dated 14/7/2022, passed in execution case number 1/2015, and accordingly, and on the basis thereof, restores the file of the execution case number 1/2015 to the file, restores the file of execution case number to the court of the principal district judge Kohima, Nagaland. This court further directs the learned court of the principal judge Kohima to to go ahead with the execution proceedings in accordance with law. In addition to that, this court further observes and grants liberty to the respondent herein to file such application to the effect that the arbitration proceedings have not yet terminated before the court below, before the said court, and the learned court shall duly consider the same in accordance with law.
Any date may not be put.
Taking into account that the parties are duly represented, this court directs the parties to appear before the learned court of the principal judge so and so on when?
9th of my lord, 8th of my lord, July.
Huh?
8th July.
8th of July. Mr. Longcha, you see one of my judgment in the case of Mukul Kolita.
Mutun Kolida.
Mukul Kolita. You will get the exactly this was happened where I have this. You take the help of these two judgments of the Supreme Court, which categorically mentions that this arbitration cannot be put to execution. It has not been served. And this will help you out, and this is how it is to be done. You make up that plea date. But without doing, you can't. I'll give him the citation you take. There, that recent two judgments of the Supreme Court are there.
8th of July, March.
8th of March?
8th of July.
But taking into account that the parties are duly represented, they are directed to appear before the learned court of the principal judge Dimapur.
No, here,
Kohima, on 8th of July 2024. The learned court of so and so shall proceed with the said execution proceedings on the basis thereof, in accordance.
Brilliant. For admission item number 2.
What is this? Criminal appeal? Admitted, not admitted? Why? Appeal is admitted. Why can it come up for admission?
Yes, Lordship. This was,
Yes, madam. Why the appeal has come up?
the High Court has, the Supreme Court has directed the
Huh?
High Court to rehear the matter. Yes.
None appears for the respondent. It appears that by an order dated so and in view of the let notice be issued for his appearance. What is this?
My lord, the lordship see the Supreme Court judgment, the order,
Uh,
Supreme Court order.
The
Supreme
impugn
Court,
order of the High Court is set aside to the extent it directed the Session Court to
Yes,
pass an
that's
order on sentence. The High Court shall hear the appellant accused on the sentence and pass
That much.
appropriate order. So what happened? Most probably the trial court, the High Court must have convicted that person and the sentence was not given.
not,
So therefore the appellate court ought to have taken into account that. Okay.
so,
Lordship,
So we will take up the appeal. It has already been admitted. You are appealing for the,
for the
accused,
respondent, for the accused.
you are the accused.
Lordship, since we have just got instruction to appear recently, 2 weeks' time may be given to us.
The counsel appearing on behalf of the respondent, number one, submits that she is appearing for the first time. First time
Yes, Lordship. This is-
today, pursuant to the notice. She therefore submits that she may be given some more time for obtaining necessary instructions. Accordingly, list the matter again on when.
After 2 weeks, Lordship.
Well, give me a date. You also have to think that when to go to the jail. You are already convicted. Huh? Hello, we have it on 22nd of July
no problem.
on 22nd
My lord.
Lordship.
for hearing.
For admission item number 3.
Please, Your Lordship, the council has some personal difficulties today.
Who?
Your Lordship, the council for the
Tell
petition.
me what is your case?
Your Lordship,
Let us
we
know
are
what
challenging
is
the
impugn
conviction.
Judgment passed by the learned principal. Judgment passed?
We're challenging the conviction passed by the principal
No,
institution.
no. If it is a judgment, we admit it. And he listed for hearing. What do you say?
Yes, Your Lordship.
Then why you are not making that submission? Records have come. LCR. There is a stay also.
Your Lordship, I'm not a counsel in the case, so I'm not aware of all the facts and
Madam.
circumstances.
You submit what is necessary. You should
Yes, Your
also take.
Lordship.
Your name is
Niti Zonyo Sono.
Yosino.
Lucino is the counsel for the petitioner.
This has come up for admission.
Yes, Your Lordship.
The instant revision application is directed against the impugned judgment dated 28/8/2017, passed by the learned principal district judge and session judge Dimapur, Nagaland, in GR case number 1003/2016, by which the petitioner was sentenced to undergo how much?
11 years of
Where
rigorous
11
punishment.
years? There is another case. Where is that? Where the order? Okay. To undergo. No, it is just 3 years, 4 years. It's directed the petitioner herein to undergo 7 years of rigorous imprisonment for offence under Section 326 of the Indian Penal Code and to undergo 4 years under Section 452 of the Indian Penal Code. It was also directed that both sentences shall run consecutively. Full stop. Taking into account that the records have already been received, this court admits the instant revision application and directs the registry to list the matter for hearing in the week commencing from 22nd of July.
Much obliged.
Huh?
Much obliged.
Yes.
For admission, item numbers 4 and 5.
Review. What have I done wrong?
Yes, Your Lordship. Lordship, we're reviewing the order dated
Which order?
26/10/2024, 2021, passed in WPC on 23 of 2019.
Then, where is that order?
Lordship, it's
26/10/2021.
yes, Lordship. Passed in the.
Okay. What is that order passed? You are
And for the review petitioner, Lordship.
review petitioner is number 5. Number 4 in the original writ petition.
No, Lordship, it was not the party in the.
Lordship,
You are not a party.
in the PPC 122 of 2019, I was
Hereby
not a party.
directed respondents should consider the petitioner for appointment to the post of so-and-so. Since the wait on the part of the petitioner's family has been so long, the same should be done within a period of 2 months from the date of receipt of the. Then, what is wrong with the order?
Your Lordship, if this order is not reviewed by this honorable court, the right to be appointed on land ownership basis of the review petitioner will be deprived.
Why?
Lordship, he applied on land ownership basis.
Land ownership. And
Yes,
he applied under,
Uh,
he applied under what?
Government High School subdivision,
Located by his father on ad hoc and the.
Subdivision Education Office, Aboy Mount.
Requirement of friends of the period applied for the post on. Petitioner also applied on land ownership.
Yes,
Yes,
Lordship,
Lord.
it happened like this, Lordship.
Huh?
The petitioner as well as the respondent, both of us applied. However, the approval order was given to another person.
You didn't get it.
No, we didn't get it. So I challenged the approval order. He just remained silent. After this honorable court passed the order in my favor, now he's supporting to bring forward to review the order passed in my case. That is the issue.
What were you doing?
Your Lordship, he had no knowledge about the repetition being filed before his honorable court.
So you have duly accepted that somebody else should get the job. You were happy with somebody else, but you are not happy with the petitioner. Something like that.
Lordship, he had no knowledge about the appointment of the.
But here there is only a direction to consider. There is not a direction to appoint. How are you aggrieved? When a direction is to consider, it would always mean the consideration in accordance with law. What do you say?
Lordship, by the statement made in the review petition, you are asking to rehear the matter, which is not permissible.
Considering the fact that Deputy Commissioner concerned after verify has certified the authenticity of the claim and the fact that the policy of the government as it stands today still permits giving of jobs to women who have donated the land for development, although the government should honor the commitment made to the father who is in the land owner. Therefore, it is hereby directed should consider the petitioner for appointment to the post of so and since the wait only. Now you have a better right.
Lordship, after upgrading the government high school from government middle school, it was on my land. The building which.
No, your
this
right
building is
against
my
the
land.
petitioner is better.
No, Lordship,
On land ownership.
no, Lordship, it is like this. Lordship, this school, it was a government middle school. The government middle school was established on my land.
Huh?
The government middle school was constructed on my land. Subsequently, the government middle school, it was upgraded to government high school. During the course of upgradation, additional four classroom was constructed on this land. That is in the year 2014. Now he also became a landowner. Both the review petitioner as well as the respondent, that's me, were both landowners. Just no dispute to that.
So it is on some other land, which is on now a part of that school, but on other land.
the lanes are adjacent to each other.
Now, have you been appointed or not?
Worship, I'm appointed. In now, by appointment, you think you're challenging the next item in the writ petition.
By filing a writ petition?
Yes, Lordship. If the review goes, if the writ petition also goes for this.
Oh, yes, challenge that order.
Yes, Lordship. My appointment.
Now, what has happened? What does the government have to say?
Worship, government need to secure.
Has the government filed the affidavit in the other matter?
Worship, in the review paper.
Huh?
In the review paper.
No, in the writ petition 52.
Remove.
Yes, they have filed. Your name is?
My name is Lauba Pupa.
Huh?
Pupa.
Your name is A. Pupa.
Yes, Worship.
H. Pupa.
H. Pupa.
H. Pupa Kohima. Now, tell me, the government, who is appearing for the government? Yes.
Lordship, it is this more. I think he's important number one. I will go and have him come.
Okay, then we do one thing. Yes, Mr. Angami, please. Kindly, just 1 minute. Here, we do one thing.
No, yes.
You have stated that in the affidavit in opposition, that you have, in compliance to the High Court's order,
Lordship.
you have granted him the appointment.
Lordship.
Now, you have not stated anything. The rights of the respondent, the number 5, vis-a-vis the petitioner in your affidavit.
Lordship.
Your specific stand is, in view of the directions passed by this court, you have complied with it and have appointed the petitioner, this person, the respondent number 5. So under such circumstances, you file an affidavit stating as regards the right of land ownership vis-a-vis the petitioner and the respondent number 5.
No, Lordship, it happened like this. In the earlier date petition, during the pendency of the earlier date petition, the department have conducted the spot verification.
So let them put it on affidavit.
Lordship, it's here. It's annexed here.
Which one?
Lordship, in
Annexed here,
the page affidavit, page number 20. It starts from page 20.
52.
20. 20.
Now in writ petition 52.
In the repetition, Lordship, in the review petition.
In review petition, it's page number 23, Lordship. Annexure H.
Huh?
Annexure H of my page 23. Review petition in my review.
Annexure H.
Yes, Lordship. Review petition.
This one. Second reminder.
No, Lordship,
Page.
Lordship, in the
In the writ petition, have they mentioned it? In the affidavit, have they mentioned it in the writ petition?
Lordship, in writ petition,
Lordship, in the-
it's at annexure.
page 26.
Huh?
From page 26.
26.
Yes, Lordship, in the repetition. Annexure I.
Verification report.
Verification report.
In inviting reference to the remand, I have the honor to submit a verification of the genuine landowner under the establishment. This is for your kind information. That page 27.
Page
I
27.
have the honor to submit the verification on the genuineness of the landowner. And it is found that the genuine landowner of the newly constructed is M. Lopa Kunir. Your name is?
My name is Pupa. Pupa.
It is also pertinent to mention that GSCs were upgraded from the government buildings located at the plot which belongs to Lopa Kunir. New buildings are belonging to the censor. And no objection to the Now, when was the new building constructed? Or and the post arose where?
The school was upgraded in the year 2014. In the vacancy arose in the year 2018.
Annexure L. So, any new post arising, you may have a right. His appointment is also right because he is also entitled. It is not that he is not entitled. So, we can't touch his appointment. It was done in the properly. This court only passed that order to the effect. He did not challenge the earlier ad hoc appointment which was given to some other person. You may not know. Very good. You may not know. You say that you have filed an appeal. The respondent government categorically says that we have not received any appeal. So what remains? Any fresh appointment, your case will be considered. We can pass that order. I think that would be without disturbing him. We dispose of both. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner in WPC number 52/2022, as well as review petition number 1/2022. I've heard Mr. Vijimomi appearing on behalf of the state respondents and Mr. So-and-so appearing on behalf of the private respondent number 5. What is GMS?
Government Middle School.
A government middle school at Saint Louis So was constructed, admittedly, on a plot of land belonging to the father of the respondent number 5. Subsequently, the said government middle school was upgraded to government high school in the year 2014. Under such circumstances, another building was constructed in the year 2014 over the land belonging to the petitioners. In the year 2019, a vacancy arose on account of retirement of one Salem Konyak peon at GMS Saint Louis So, Mon. The government of Nagaland had forwarded the names of the petitioner herein, the respondent number 5, as well as one Sri Longsing S. Konyak for further necessary action and decision. The government of Nagaland, by the letter dated 26/7/2019, accorded approval for ad hoc appointment in favor of Sri Longsing S. Konyak. This approval letter dated 26/7/2019 was challenged by the respondent number 5 in WPC number 123/2019, praying for a direction to direct the state respondents to appoint him against the aforesaid post on land ownership basis, and also for setting aside and quashing the approval letter dated 26/7/2019. It is an admitted fact that the petitioner herein, however, did not challenge the said approval letter issued in favor of Sri Longsing S. Konyak, or nor approach this court, approach the authorities. This court, by the judgment and order dated 26/10/2021, disposed of the said petition being WPC number 123/2019. Thereby directing the respondent state to consider the petitioner for appointment to the post of the peon lying vacant in the government high school at Saint Louis village. But the post was in GMS.
Government Middle School.
Then why the direction is to government high school?
Bishop, after the school has been upgraded to high school, now it has been named as Government High School.
But then also the post, here they say it is still in government. Anyways, it was also directed that the said appointment should be, said consideration shall be carried out within a period of 2 months from the date of receipt of the order. Pursuant thereto, the petitioner herein, the respondent number 5 herein, was appointed by the letter dated Where an order dated 25/1/2022. It is under such circumstances the review of application was filed, being review petition number 1/2022, seeking review of the order dated 26/10/2021 on the ground that the petitioner herein was not a party to the said proceedings. In addition to that, the present writ petition has also been filed challenging the appointment of the respondent number 5 on the ground that the petitioner herein has a better right. Full stop. The record reveals that in both the review petition as well as also in the writ petition, the state respondents have filed their affidavits as well as also by the private respondent number 5. Full stop. In the said affidavit, it has been mentioned, it has been duly admitted that that one building of the GS Sense Loiso was constructed upon the land belonging to the father of the respondent number 5, and the second building was constructed on the land belonging to, donated by the father of the respondent of the petitioner. It is also clear that the land of the respondent number 5 was taken prior to the land of the respondent petitioner. It is apparent. Yes. It is also seen from the verification report dated 10th of May 2021 that this aspect of the matter had been duly admitted. The record also shows that this court have duly by the order dated 26/10/2021 in WPC number 123/2019 have duly considered that the petition respondent number 5 has due case ought to be considered, and had duly considered that the respondent number 5's case ought to have been considered by the respondent authorities, in as much as the respondent number 5's father had duly donated the land and accordingly passed such directions. Under such circumstances, there cannot be said that there is any error apparent on the face of the record in the order dated 26/10/2021 passed in WPC number 123/2019. Thereby to invoke the review jurisdiction of this court. In addition to that, this court also observed that there is no other grounds available also for reviewing the order dated 26/10/2021 passed in WPC number 123/2019. The consequential effect is that in view of the order dated 26/10/2021, the respondents have duly appointed the respondent number 5. The said order, therefore, which have been the appointment of the respondent number 5, therefore, have been in pursuant to the order passed by this court. There is nothing on record to show that there's nothing on record which have been shown by the petitioners herein that the petitioners is only entitled to there's nothing on record which has been shown by the petitioner herein that the respondent number 5 father did not donate the land. It is also apparent that the respondent petitioner's right had accrued at a later stage than that of the respondent number 5. Under such circumstances, this court is of the opinion that the petitioner herein that the appointment of the respondent number 5 cannot be said to be illegal or arbitrary or in violation to the policy of the respondent authorities in granting the in issuing the appointment letter, in issuing the order dated 25/1/2022, thereby appointing the respondent number 5. Accordingly, this court finds no merit in the review petition as well as also in the instant writ petition. Next. Before parting with the record, this court, however, observes that it is an admitted fact that by the respondent authorities in their affidavit that the petitioner's father had also donated land for the construction of the second building in GSHS Sensilo in Namta. Under such circumstances, whenever any vacancy arises, the petitioner would also be entitled to be considered for on land ownership basis. With the above, both the review petition and AR stands dismissed.
Next question.
Courtmaster sir, when the court will resume? Courtmaster sir, when the court will resume? Sir, when the court will resume?
After 5 minutes.
For admission, item number 6.
May I please, Your Lordship? The counsel for the respondent number 2 is indisposed to Your Lordship, so, and then I've taken the consent of the petitioner also. Kindly list this matter for hearing.
Yes,
Lordship, I've taken the consent of the petitioner and the respondent number 2's counsel is indisposed today. So kindly list the matter for hearing.
when?
Lordship, I've the convenience of this court.
None appears on behalf of the petitioner on call.
Milords, I am appearing for the petitioner.
You are appearing for the petitioner?
Milords,
Yes.
I am from Imphal, representing the petitioner now.
Okay, tell me, what is your case about?
This is about postman of certain affairs, including the 420 IPC.
Yes, why?
So, this is based on the non-establishment of prima facie commissions on the part of the present accused persons, that is the petitioner. It indicates and revealed in the investigation itself that other than the one Burger, who happens to open one infra that's company, there is no any such accused persons who can be just penalized. That is also clearly mentioned and revealed in the investigation. So, moreover, it has been converted into civil matters when the affidavit of the opposite party, there is a present respondent number 2, is concerned, there has been reduced into writing. I mean, like, Lordship, the same has been reduced into writing and reduced into agreement. So, the prima facie established of commission of crime on whatsoever on my part doesn't arise at all. That is also clearly established in the charge sheet. So,
Charge sheet has been submitted.
Submitted.
So, what is have they said anything against you?
I may take your lordship to page number 15 of my petition. Where in the last sentence, during investigation, let me read out your lordship. Page number 15, last para.
Investigation, the accused person.
During investigation, the accused person alleged the involvement of Entiluang in the commission of offense. That is the allegations of the persons who is languished in the jail right now. However, during thorough investigation and from records available, it is ascertained that the accused Abhishek Bargav, alias Abhishek Bora, is the sole accused who opened and registered the company from MCA ROC Shillong as the chairman of the company MS View Image Infratech Private Limited. He also prepared and signed letter of intent and affidavit agreements in order to falsely assure the complainant. No prima facie concrete evidence could be established against the other accused, Entiluang. This is me, your lordship. Entiluang is the present petitioner. However, efforts were made to locate the other suspect, Entiluang, for his exemption to establish his involvement. But despite so and so could not be located since the accused could neither provide the full particulars nor the complete residential address of the other suspect. In this regard, it would be significant to mention that my capacity in the present, the then company was only as a manager only. On the strength of being a manager, I run here and there for carrying out the present project, which is alleged to be.
No. You were never arrested.
Never arrested. It was of the year 2011, 12 about this the alleged project. Yet the FIR is registered only in the year 2017. Thereafter, it culminates into filing of charge sheets. Why my address and all those things cannot be located is I was simply
Abhishek
acted.
Bora was arrested. Only Abhishek Bora was arrested.
He has been arrested in numbers of other cases also,
In
and
this case, he was arrested.
I have never been arrested.
No, Mr. Counsel, only Abhishek Bora was arrested.
Yes, Your Lordship.
So and therefore the charge sheet has come to page 16.
Mhm.
A prima facie case charged under 406 for the offense of criminal breach of trust is found well established against the arrested person.
Mhm.
So you were not arrested.
Yes, not arrested.
The arrested person took in. Then a prima facie case under 420 so and so delivery is well against the arrested person. So under such circumstances, we can push your thing.
Milord, as far as the revelations that investigation is concerned.
Yes, and no, because the investigation you have already been said that you have nothing to do. If they are aggrieved, then they have to approach the court under appropriate proceedings for a protest petition. That's the law. If you agree with this person,
Lordship, I'm not in this case, Lordship.
who are you?
Lordship, I'm only appealing.
Yes, Mr. Vijimomi is there. You are the PP. Yes, tell me, if a person in the FIR, you may have made many allegations. Now your police officers comes out and files a charge sheet saying, yes, there is a case against A, but there is no case against the petition. And as such charge sheet has been, which is the final opinion. The final opinion is given. Now on the basis thereof, can the court proceed? Unless the court exercises the powers of going for further investigation in terms of 173(8), the court cannot. So the court may go to that or may not, or even the respondent number 2, if he is aggrieved, he can very well go. But as regards this challenging of the FIR has become now useless in view of the charge sheet is not against them. So the FIR, challenging of the FIR has, whatever has been challenged out here has no longer remains. Isn't that the law, if I'm not wrong? You are not there in the case. Isn't that the law, Mr. Takamasa? If a FIR has been filed against two persons, A and B, the investigation officers comes up and categorically says that there is only case against A, I filed, submit the charge sheet against A. What remains of that FIR against B becomes useless.
Because you only say against the arrested person.
Only and only he can, if they are aggrieved, the respondent number 2 is aggrieved, they can very well go against and file appropriate application before the authority, saying before the court, saying or filing a protest petition that this person is also equally involved. So that court has to take note of. Yes, now who are you?
Lordship, I'm appearing for
Tomorrow? Ask him
Not-
to appear tomorrow. This is a short matter, we finish it. Okay, Mr. Counsel from Imphal,
Milord,
we'll have it tomorrow. We quash the FIR insofar against you.
Milord, not tomorrow.
You are there in
I will be very much busy tomorrow.
very,
Milord, sir.
very, if you are
And
very,
at least 2 days.
no, not necessary. I've already heard you. I'll quash the FIR against you. Matter unnecessary should not remain. Because what has happened, the case is here now. Let the trial proceed against that person. Against the Abhishek Bora. Let it proceed against him. But unnecessary keeping this file here doesn't make any sense. Because there is no charge sheet against you. The court cannot frame charges against you, cannot issue notice to you. Nothing can be done. So under such a one, nothing remains in the criminal petition in view of the charge
Yes.
sheet.
Yes, Milord.
Okay.
In the meantime, Milord, I may be allowed to submit the citations.
Counsel appearing on behalf of the petitioner. There is only one petitioner.
Yes, Milord.
The counsel appearing on behalf of the petitioner has been duly heard. I've also heard Mr. Vijimomi, the learned PP, Kustum. The counsel appearing on behalf of the respondent number 2-6 for an accommodation for the day. List the matter tomorrow as doing it as part of it.
Right.
Maula Ismail.
For admission, item number 7 and 8.
Lordship, here the leading counsel, Senior Advocate H. Rahman. He had undergone surgery in Delhi. He's currently in Delhi, Your Lordship.
What is this matter about?
Lordship, item number 7 is to quash the criminal complaint against the petitioner. And item number 8, this criminal revision is against the order passed by the JMFC Dimapur, 16/11/22. Rejecting my
Quashing of a complaint case.
Lordship.
Yes, who is appearing? Yes, Mr. Jimami, what is this case?
Lordship, one is for quashing of complaint.
Why? Civil dispute.
Lordship. Lordship, because the dispute arose out of the MOU, Lordship.
Hmm?
The dispute arose out of MOU.
Ah,
So our stand is like it's a civil in nature, Lordship.
so your case is that this is a civil dispute.
Civil dispute, Lordship. And there is a clause for to approach the
Who is appearing for the private respondent?
Then in Kilkan
He's not here?
is not here.
Okay. Taking into account that the respondent number. Why are you not making the state a party?
Lordship, we have recently made a state a party.
Recently.
A notice, they have accepted the notice.
Okay. Oh, that is why you filed this amended
Law. Lordship.
You are enjoying a stay?
Lordship, at the moment, yes, Lordship.
You want to enjoy your stay further?
Absolutely, Lordship. Is
You wanted the enjoyment of stay further, then you have to argue the matter.
Lordship, without the instruction from senior, I cannot, Lordship.
So what? First of all, this court does not grant any adjournment on senior advocate. I'm very clear on that.
Lordship, I appreciate that he had undergone a surgery, Lordship, in Delhi, Lordship.
Senior advocate, you change it. Change him, have another one.
Lordship, just 10 days after 20, any date after 20. Lordship.
No, 3 days. Adjournment. You want an extension is granted.
Lordship,
You see, first of all, Mr. Counsel, I make it very clear. From the date I have become a judge, I don't grant adjournment on senior counsels. You may have difficulties, I may give you. That is a different thing, but not on the ground of senior counsel. Make it very clear. Don't ask adjournments on senior counsels. Senior counsels are different. They are on day-to-day basis. Do senior counsels sign wakalatnama?
No, Lordship.
Because they are not required to sign wakalatnama. They only address the court on the basis of what you say. You can engage any senior counsel anytime. You want senior counsels from Gauhati, there are hundreds nowadays. Get anybody from there. Or here you have Mr. Takamasa there.
It's not up to me, Lordship.
You can't have it. Okay, I want this A senior counsel. Therefore, in Supreme Court senior counsels, even names are not reflected in the cause list. We are also taking steps in the principal seat. The senior counsel's names have to be removed because they cannot be. When they don't sign the wakalatnama, how can their names be reflected? They may change, keep on changing.
Lordship, may please consider the prayer after 10 days, Lordship, any day after 20.
Huh?
Any day after 20, Lordship.
20. Why?
Which I've been instructed to pray before, Lordship.
No. Your name?
I, Jamir, Lordship.
I, Jamir, heard Mr. I, Jamir, the learned counsel appearing on behalf of the petitioner. Mr. V. Jimomi, the learned PP. appearing on behalf of the state respondent. Full stop. The instant matter pertains to quashing of CR case number 17/2022. And full stop. It is seen that the matter has been pending since long. Full stop. Accordingly, full stop. However, taking into account that the complainant, the counsel for the complainant is not present today, for the interest of justice, the matter stands adjourned to be listed again on Thursday. Give the date. 13/6. 13/6. 6. Interim order passed earlier shall continue till then.
Last question. For admission, item number 9.
Yes, what is this?
Lordship, here also.
Don't
the
come
same-
again with the same prayer.
Lordship, I was also told that she's yet to file her counter.
On perusal of the same, quash and set aside the order passed by the DB fact.
My lord, I'm yet to receive the affidavit in opposition.
Not necessary. Why
Yeah.
you are challenging the DB order here?
Exactly, yeah.
You go.
So I want the matter to be heard as it is.
Why? Let the DB decide.
Yeah.
Let the DC decide.
No,
You
I
file
want
a
this
case
matter
on
to
the
be
31st.
tried de novo
Huh?
in an appropriate civil court,
Where?
a PAC.
Let's see the order. No, whenever a DB order is passed, if I am not wrong,
Yes,
you have a right on the 31.
yes.
You approach on the 31.
I've approached the DC.
Ah.
The DC has endorsed the matter to the DB court again.
They can't.
They can't.
Against the DB order.
Yes.
We set aside that order.
For that, I'm praying this honorable court pass an appropriate order,
I'm praying.
directing the civil judge.
No, I will ask the DC to decide him by himself or through his delegate in terms with 31. Or he may refer it to the DC judge as per his thing.
Right.
I think that is the only way out.
I've got no.
Because that day there was a huge problem when another matter which I have taken up in that court. Here, what he was doing here, when you move on the 31, the exercise of the power is done on the 23A.
My lord.
This is what has happened.
Yes.
And if it is done on the 23A, the Dobashi court cannot sit over again Dobashi court's order.
Exactly.
Yeah.
Lordship,
Don't come up with an adjournment prayer. It's just such a small matter.
Yes.
Lordship, it may be heard before the appropriate counsel, Lordship.
Who is the appropriate counsel?
Nancy Lota for all the respondents.
He's coming tomorrow?
Yes, the other
Tomorrow.
matter is also fixed, so.
The matter having been heard, let's the matter again on. I've heard the learned counsel appearing on behalf of the petitioner, and the counsel, however, Ms. So-and-so appearing on behalf of the private respondent submits that an additional opportunity be given for her to make appropriate submissions tomorrow. List the matter tomorrow.
My lord, item number 12. Let this matter also be heard together, because I was not aware that item number 12 was coming up.
Okay.
I've not been instructed by my junior. I didn't bring the files itself.
Okay.
So let this matter also come up tomorrow.
Jameen? Item number 12.
12, my lord.
Mr. So-and-so, the learned counsel appearing on behalf of the. No, item number 12, we can't have it because we don't have the respondent.
My lord, here in this matter, we have given a notice to the opposite party through press. They have not.
Let me. Okay, it is for orders. I will take care of it. Let me pass an order separately, because if I have to deem service notice, so that will be a separate order. Okay, we just wait for 5 minutes. We'll finish. Wait for some time. You don't need the file for
For admission, item number 10.
Lordship, I applied for 2 weeks' time to file counter affidavit, Your Lordship.
What is this matter?
Now, the petitioner is before Your Lordship praying for quashing of the criminal complaint, Your Lordship. And petition
Quashing of
the criminal complaint which has been filed by the respondent. And the petitioner, Your Lordship, he is the resolution professionals, Your Lordship. Now, against the company, corporate insolvency resolution process is going on. Now, the respondent has filed a criminal complaint against the company who is represented by the petitioner, the RP, and also the then director, Your Lordship. So the director has approached this honorable court by way of filing a criminal revision for of 2023. And by an order dated 27/2023, Your Lordship, this honorable court was pleased to quash and set aside the criminal complaint. Against that, Your Lordship, an SLP has been filed that is pending before the Honorable Supreme Court, Your Lordship.
Against this?
Yeah, no, against the order. So, where the accused director was before this court. And then against that criminal complaint was quashed and set aside against the director, Your Lordship. So against that, and SLP has been prepared, Your Lordship, and that is pending disposal before the Honorable Supreme Court. This is the order passed in the SLP, Your Lordship.
Lordship, may I say?
Yes, tell me.
Lordship, I am the resolution professional of the corporate debtor, Lordship. The recent development is, Lordship, the resolution plan has been approved by the National Company Law Tribunal on 30th May 2024, Lordship. And now Section 32A will prevail as per the Insolvency Bankruptcy Code, Lordship. So as per the Section 32A, the new promoters, no prosecution or no penalty can be imposed against the new promoters, Lordship. Lordship, may I read Section 32A of Insolvency Bankruptcy Code, Lordship?
Okay. IBC.
IBC, Lordship.
Yeah.
Lordship, as per Section 32A of the IBC, Lordship, liability for prior offence, Lordship. This offence is the prior to the CIRP, Corporate Insolvency Resolution Process, Lordship. Section 32A, Lordship, notwithstanding anything to the contrary contained in this code or any other law for the time being in force, the liability of a corporate debtor for an offence committed prior to the commencement of the Corporate Insolvency Resolution Process shall cease, and the corporate debtor shall not be prosecuted for such offence from the date of the resolution plan has been approved by the adjudicating authority, that is NCLT, under Section 31. If the resolution plan results in change,
that's a liability. We are concerned about a criminal offense.
Lordship.
Yes, Lordship.
No. Kindly. There's a mass distinction. Whether a case is made out, whether a resolution professional, you are a resolution professional.
Lordship.
Yes, Lordship.
The RP or the RP has done it properly or not. These are aspects, or whether they are there's a they are not to be prosecuted. These are other aspects of the matter which is different. But a question of liability is a different aspect of the matter.
Lordship, may I read?
Let them file the affidavit. They want to file an affidavit.
Lordship, although my responsibility has been closed, Lordship, because the resolution plan has been approved, but I will file the affidavit, Lordship.
No. A resolution plan have been approved.
Yes, Lordship.
By the
Adjudicating authority.
By the NCLT must have done it.
Lordship.
Yes, Lordship.
The NCLT, if the resolution plan have been approved, that is another thing by which the resolution plan has become final.
Yes, Lordship.
The NCLT must have thought that you have done the commendable work, rightly so. But the question is whether a criminal offense is made out or not is a question which needs to be decided on a different thing, unless there is a provision in the IBC whereby there cannot be a prosecution in exercise of the powers when a resolution professional exercises the power, because resolution professional exercises the powers on the 7th, after the initiation of the 7th. So therefore, let him file an affidavit. He wants to file an affidavit.
But as per Section 32A, new successful resolution applicant will pursue the application, Lordship. But as per Section 32A, no prosecution can be continued against the successful resolution applicant, Lordship.
Against the
successful resolution applicant, Lordship. Now the successful resolution applicant is come in the picture, Lordship. At Section 32A clearly says that no prosecution, no penalty can be imposed against the successful resolution applicant after the approval of the plan, Lordship.
Let me see.
Lordship, please read Section 32A, Lordship.
offense. Notwithstanding anything to the contrary contained in this code or any other law for the determining the liability of the corporate debtor for any offense committed prior to the commencement of the corporate liability resolution process shall cease, and the corporate debtor shall not be prosecuted for an offense for the on the date of the remainder has been approved by the one under section in the agreement. A promoter in the management, a person with regard to whom the relevant investigating authority have in the basis of the legal prosecutor during the corporate insolvency resolution against the corporate debtor shall stand discharged from the date of payment. But does it provide any immunity to a resolution professional?
Lordship, there is no rule of the resolution professional, Lordship. The resolution professional is appointed after the CIRP initiated, Lordship. And this offense is prior to the CIRP, Lordship, against the director, Lordship.
The offense is against whom?
Against is committed committed by the directors prior to the CIRP, Lordship.
No, against whom is the criminal offense that the FIR has been filed?
Against
Lordship, company and other two directors, Lordship.
Where is the FIR? Where is the complaint? Yes, CSA Corporation Limited, UMD in Gaurav having registered office here.
It was filed against the company and the director.
Accused number 2 in this context. Who is accused number 2?
He's the director.
Directors of the company.
So he has approached this court by way of filing criminal revision for.
No, this is filed by some Rajiv Bhatnagar.
Lordship, Rajiv Bhatnagar is the resolution professional, Lordship. I am the Rajiv Bhatnagar.
He is.
Now, do you have any business out here? After the resolution, after the proposal having been accepted.
Section 20.
Because the role of our RP is ends
there. Section 22.
The role of the RP ends.
Yes, Lordship. After approval of the resolution plan, the role of the RP is closed, Lordship.
So under such, can you maintain this petition?
The locus.
No,
it takes its course in view of 32A. That's a different aspect. But can you press this petition now?
No, Lordship, because the successful now the monitoring committee has been constituted, Lordship, and till the disposal of the monitoring committee, I am handing over the charge to the successful resolution applicant, Lordship.
Understood everything, but as a resolution professional, your role has already ended.
Yes, Lordship.
Under 32.
Yes, Lordship.
Under such circumstances, can you still maintain and appear? Because you were appearing at that point of time because you were in charge.
Correct.
Of
Yes,
that particular company.
Yes,
being
Lordship.
appointed as a resolution professional. But with your role having come to an end, do you have anything to say now on this basis? You have no business.
Yes, Lordship. There is a substitution application will be filed by the SRA, Lordship. Still, the substitution application is not filed. That's my duty to appraise the court, Lordship.
Whoever it is may very well come up before this court or AR for quashing out there because of 32A. Absolutely. Under 32A, he will very well come in because you see no offense which was there against the company or its director can have anything to do with it. There's no offense. It is clear under 32A. But can you maintain it?
No, Lordship, because the resolution plan has been approved only 30th May. 30 May 2024, Lordship.
Understood. We're still 10 days after.
10 days, Lordship. So, Lordship, it's my duty to appraise before the court, Lordship.
No, understood. But can you now?
No, Lordship, I cannot pursue the application, Lordship.
Yes.
You cannot therefore pursue this application. However,
Lordship.
it will be there to the company or
Yes,
the
Lordship.
subsequent company who have taken it over.
Yes, Lordship.
Challenge whatever it is.
Lordship.
We can close it.
Yes, sir, Lordship.
Yes.
You can close it, Lordship. With the direction, Lordship, with the direction to the Dimapur court, Lordship, the name of the resolution professional shall be removed from the summon, Lordship. Because the summon has been issued to the resolution professional, Lordship, by the Dimapur court, Lordship, CGM Dimapur, Lordship.
Where is the summons?
Lordship, annexure P17, page number 427 or 432. Page number 437, Lordship.
17. Page. Page.
Page Lordship, 427 Lordship.
427. Okay.
Lordship, actually this application has been infectious, Lordship.
And when was it filed before the NCLT?
Lordship, original application 13/12/2021, Lordship, 13 December 2021.
Okay,
The
so
CIRP has been admitted.
all these allegations were prior to there too.
Yes.
Yes, Lordship.
And prior to you being appointed.
Lordship.
Yes, Lordship. My appointment has been on 10th January 2023, Lordship. I am appointed 10th January 2023.
I'll make it very clear then. Your appointment was 10th of
January 2023, Lordship.
January 2023.
By the Honorable NCLT, Lordship.
And NCLT, which one?
NCLT Daily Bench, Lordship.
Delhi.
Daily Bench.
Delhi.
Daily Bench.
NCLT, which one? Delhi.
Yes,
It's Gauhati.
No, Lordship. NCLT Daily Bench.
Delhi is different. This is Delhi. This is Delhi.
This is NCLT Delhi. But there is another one here.
Yes, Delhi. There was also proceeding there, but we are concerned with NCLT Delhi.
It was done in NCLT Delhi. They appointed him.
Yes, Lord.
On 10/1/2023. And it was approved, the resolution AR was approved on 30/5/2024.
Yes, Lordship. 30th May 2024, Lordship. Resolution plan has been approved.
Resolution plan has been approved.
Yes, Lordship.
Okay. Yeah. Heard Mr. Rajiv Bhatnagar, who is present in person through video conferencing. Mr. TB Jamil appears on behalf of the respondent number one. One. And who is State of Nagaland? Where is Mr. V. Zimomi? Yes, Mr. V. Zimomi appears for the respondent number 2. The petitioner herein was an interim resolution professional. The petitioner, Mr. Rajiv Bhatnagar.
RP.
Lordship, I am not the interim resolution professional, Lordship. I am resolution professional.
What?
I am resolution professional, Lordship.
Yes.
Not the interim resolution professional, Lordship.
Okay. Mr. Rajiv Bhatnagar was appointed as a resolution professional by the National Company Law Tribunal, New Delhi, under Section 9 of the Insolvency and Bankruptcy Code 2016.
This bracket, New Delhi bench within bracket Court 2, Roman 2.
New Delhi Court Roman 2.
So New Delhi bench.
No, it's okay, not necessary. Was appointed as so and so by the NCLT New Delhi under Section 9 of the Insolvency Bankruptcy Code 2016 by an order dated 10/1/2023. It has been brought to our attention that in view of the fact that the said Rajiv Bhatnagar, Sri Rajiv Bhatnagar was the resolution professional. He filed the instant application for quashing of where is the complaint?
CR 12 of 22.
Where the complaint?
And next year.
Complaint where? Yeah. Washing of CR 12/2021 filed by the respondent number 1 herein against MSUM Green Lighting Private Limited and Sri Gaurav Mamik.
Your Lordship, I am filing the question complaint against the corporate debtor, Lordship.
Mr. Bhatnagar, you have any problem, go to the Supreme Court. I'm writing whatever I know.
Sorry,
Don't recall all these things. Don't disturb this court any further.
Sorry, Lordship. Sorry. Apology, Lordship.
The reason for filing the instant complaint application, this application under 482 of for the reason for invoking the jurisdiction of this court under section 482 of the Code of Criminal Procedure 1973 is on account of a summons issued to Sri Rajiv Bhatnagar as interim resolutional professional for MSUM Green Lights Private Limited. This court have also taken note of the complaint so filed being CR number 12/2021, which categorically shows that the allegations so made against the accused number 1 and 2 in the said complaint are all allegations during the period prior to the said Sri Rajiv Bhatnagar appointed as the interim as a resolution professional. Therefore, it has also been brought to the attention of this court that on 30/5/2024, the National Company Law Court Tribunal, NCLT, Law Tribunal, had approved the resolution plan in terms with section 31 of the Insolvency and Bankruptcy Code 2016. It is seen from a perusal of section 23 of the Insolvency Bankruptcy Code 2016. That the resolution professional shall conduct the entire corporate insolvency resolution process and manage the operation of the corporate debtor during the corporate insolvency resolution process period. The proviso to subsection 1 of section 23 also stipulates that the resolution professional shall continue to manage the operation of the corporate debtor after the expiry of the corporate insolvency resolution process period until an order approving the resolution process plan under subsection 1 of section 31 or appointing a liquidator under section 34 is passed by the adjudicating authority. Taking into account that on 30/5/2024, the resolution plan have already been approved by the NCLT Delhi. The role of Sri Rajiv Bhatnagar as a resolution professional of MSUM Green Lighting Private Limited had come to an end. And his duty is only limited now to take steps in terms with section 31(4) of the Insolvency Bankruptcy Code 2016. Under such circumstances, this court is of the opinion that the instant petition now cannot be maintained at the behest of the Sri Rajiv Bhatnagar, who was the resolution professional. This court further quashes the summons which was issued to Sri Rajiv Bhatnagar enclosed as Annexure P17 to the instant complaint petition dated 16/1/2024. This court further observes, before parting the record, this court further finds it relevant to take note of a submission made by Sri Rajiv Bhatnagar, resolution professional, to the effect that in view of section 32A of the Insolvency Bank and Bankruptcy Code 2016, the said criminal proceedings cannot further be continued. Taking into account that with the approval of the resolution plan, the role of Sri Rajiv Bhatnagar has come to an end. This court would not deal with the said submission. However, the liberty would be available to the to whom? Yes, Mr. Bhatnagar, to whom?
Successful resolution applicant, Lordship.
Huh?
Successful resolution applicant, Lordship.
Successful
resolution applicant, Embrace Pipe Limited, Lordship.
Where is the term?
Successful resolution applicant, Lordship.
Where is it? Can't use a term like that. To the successful resolution applicant to take such a plea before the appropriate court. With above the instant petition stand disposed.
Abulash.
The CR, it's a scan copy only, no? There's a state.
Yes. Yes, this interim order is there.
The interim order therefore stands vacated.
Abulash.
Okay, Mr. Bhatnagar. I release you from this thing. The summons against you as quashed.
Highly obliged, Lordship. Highly obliged. Sorry, apologies, Lordship, by interrupting, Lordship.
For orders, item number 11.
Yes, Mr. Takamasa.
My village, Your Lordship.
Why the matter has come up for orders?
Lordship, the respondents 4 to 9 are yet to file their affidavit.
They have not filed?
Lordship, then Lordship.
Affidavit.
It appears, Muller affidavit filed, but not served to me. 4 is already filed. 4 filed, it appears.
Yes, 4 has filed. That is a counter affidavit on behalf of 4 to 9 not filed. So 5, 6, 7, 8, 9 has not filed.
Yes.
Mr. Jamil, you have
I have for 2. Course 1 number 2, I have 5.
You have filed.
My lord, I'm for 7 and 8.
You have not filed.
7 retired from service.
That doesn't matter, Lordship.
So, well, at that point of time, whether they were in violation, isn't it? There are 2 things. One is enforcement, one is violation.
Yes.
Enforcement, Mr. Jamil and Mr. Imsong is there. For you, why should you not be sent after your retirement to jail?
New incumbent may be inflicted.
No. My lord,
incumbents are all there.
By virtue of being member of the committee, Lordship, not by virtue of the post. By virtue of the expert
anyway, you file your affidavit. How much time?
My lord, on that point,
3 weeks time.
Lordship may kindly see, Lordship may kindly see the order on 4th of April. 4th April.
Where is that order passed by this court? Oh, this one.
Village cards.
Is a division bench order?
Yes. Lordship, kindly allow me to I'll make
paragraph 29.
Direction was to examine expert committee to be set up to examine and determine. Thereafter, my lord, an expert committee was constituted. Now the expert committee did not submit the report, but the expert, the dishonorable court, single bench, has come to a conclusion that the report was not in terms of the direction of the Learned Division Bench, and that the further direction was given to strictly comply with the judgment. In accordingly, a fresh committee was constituted, and the fresh committee has simply reiterated the earlier decision.
So you said that this is not in terms with that?
No, Lordship.
Now tell me, how can this court exercise if there is pursuant to anything is being done? Yes, that is one. The contempt will remain, but for passing appropriate orders that this is not in accordance with that, can it be done in a contempt?
My Lord, the issue is this. I have made a clear submission. My Lord, on 5/12/2022, the learned single judge passed an order that it is not in compliance because Lordship relying on the judgment of the Honorable Supreme Court, which says that partial compliance is no compliance. I had relied on that judgment, and the learned single judge had accepted that judgment submission. An order was passed on 5/12/2022, directing for further constitution of the committee and to comply strictly in accordance with the judgment of the learned single judge as division bench. He did not file any appeal against that order. Rightly or whether rightly passed or wrongly passed, that order has attained its finality. And in terms of that direction of this of the learned single judge on 5/12/2022, the second committee was constituted. So my plea in the affidavit is that since no appeal has been filed against the judgment of the learned single judge, I appreciate what Lordship is commenting. But rightly or wrongly, that judgment has attained its finality. The judgment of the order of the learned single judge. Because the learned single judge.
Mr. Takamasa, what do you say? That was a form of an interim order. So unless there is a sentence given in a contempt matter,
the issue
an appeal does not lie.
My Lord, the issue is this. The learned
Mr.
single.
Takamasa, I think I should not make them further clever.
Yes.
Now let them ask them, yes, why it has not been done.
Lordship,
There was a specific direction.
Yes.
The division bench made it very clear. We are not concerned with how many committees you form or not. The law is, in the paragraph number 29 is very clear.
Yes.
In that view of the matter, we direct the state respondents to constitute an expert committee to examine and determine the payment entitlement of the financial benefits of the village guards in consultation with the Ministry of so-and-so. The expert committee shall include representatives of so-and-so. The committee should be chaired by the officer here. The committee should be constituted as directed herein above within 3 weeks from the date of receipt of the and should complete the process of examining the matter of enhancement of the honorarium and other allowances of the Imam as expeditiously as possible and not later than 4 months from today. While considering the matter of enhancement of honorarium and other allowances as directed above, the committee shall also take into observations of the directions by the apex court in paragraph 39 in the case of Grahak so-and-so. The recommendations may be forwarded to the state government in the home department and also to so-and-so. Now, what does in Grahak Singh it has said? It must be somewhere noted.
My Lord, that judgment says, my Lord, then that judgment of the Honorable Supreme Court relates to home guards. Now, what has happened is the home guards in India who are enjoying fixed pay, who are not regular employees, has approached the Honorable Apex Court for regularization of their services. Now, the Honorable Supreme Court rejected their plea on the ground that they were not appointed against a sanctioned post and they are not regular employees. But in view of the fact that you are performing while performing duty, since they are performing the duty of a policeman, the Honorable Supreme Court has given a direction that he should be paid the salary of a constable. In view of the fact that they are performing the duty of a policeman, that was the direction. Now, my Lord, what has happened is the committee was constituted, and when the committee was under consideration, it's a classic case of putting the cart before the horse. The state government wrote a letter to the government of India seeking your opinion, and the government of India replied on 14/12/2021 that in view of financial constraint, we cannot. And those letters were also part of the consideration before the learned single judge on 5/12/2022. My lord, this matter, since on 4th April, last chance was given to the respondent that in the event you don't file your affidavit, Lordship, matter can be heard on the basis of the record available. Then, Lordship, on 7/5, the matter was listed, but unfortunately, my two learned friends were absent, so I did not press. But since our affidavit is filed, kindly allow me to go through it and we can dispose of this case on Thursday. Since respondent number 4 has filed an affidavit and not served to me, just give me the opportunity to go through that. And of course, the others has not filed an affidavit. But the order is very clear on 4th of April.
Your Lordship, I represent the respondent number 9. So respondent number 9, 4 is already filed the affidavit. And 9 is he has underwent maxillofacial surgery in New Delhi, 2022. So every now and then he require a medical attention. So here, respondent number 9, he was never a member of the expert committee. And subsequently, as stated by our petitioner counsel, reconstituted committee, expert committee. There also respondent number was never implemented as a member of the expert committee. But Your Lordship, as stated, since he was a patient, every now and then he has to go down to Dimapur, get the medical attention, so he could not take the timely step. As to why he was implemented as a respondent number 9. So, Your Lordship, in the meantime.
No, Mr. Kindly appreciate. Ms. Board understands all your problems, but only thing, there is a direction to consider the case of the petitioners in terms with that Grahak's judgment.
Yes.
Have you done it?
No.
That has been done. In my affidavit, I have clearly mentioned.
So as per you, they have duly considered that. That is what your stand is.
Yes.
I filed my affidavit in reply.
Have you got his affidavit?
Yes, I have filed my affidavit in reply.
You have filed the
Denying that.
Your Lordship, in my case.
And his affidavit you have got it
Yes,
in the morning.
I'm here to receive.
4.
Hello.
Your Lordship,
I'm here to receive.
When you want the matter then?
My lord, may I pray that let the matter be released? So because
When?
kindly keep me, if after going to affidavit, if I need to file my reply, then I need at least 2-3 days. So next week, Thursday would be too early for me to file my reply, Lordship.
Even 2 weeks time.
No, Lordship. 4th April order is very clear. So let it be on Tuesday. Next Tuesday, by then I'll file my reply. Whether he filed or not, that's a different issue. Because sufficient time has been given.
Okay. Mr. Takamasa, the Learned Senior Counsel submits that his junior has been served with a copy of
You have to be served. You have to be
is
served.
yet to be served a copy of the affidavit filed by the respondent number 4.
Yes, Lordship.
Mr. Ayum Song, the counsel appearing on behalf of the respondent number 4.
4 and 9.
4 submits that he will be serving the copy during
Yes.
the course of the day. So taking into account the above, Mr. A. Santam, the learned counsel appearing on behalf of respondent number
LD Santam.
for 7 and 8. 7 and 8 submit that he may be granted 2 weeks' time for filing a. Taking into account that earlier there is categorically this court made it clear that no further adjournments would be granted for filing any further affidavit. This court fixes the matter again on Twenty 2024. In the meantime, the petitioner herein would be at liberty to file their reply, and the respondent number
7 and 8.
7 and 8 shall be also at liberty to file their reply.
Much obliged, Lordship. For orders, item number 12.
My lord, I pray this matter be listed tomorrow.
Tomorrow, let's see.
My lord, yeah.
Let's see what is the service. The superintendent and will file under section 2. I can't do that. Because notice has been issued only on 6/6. Only on 6/6.
My lord, in this matter, there is some IAS also.
In that earlier matter, they are appearing.
Yes, yes.
Okay. The council appearing on
I think,
behalf
that,
of
my lord, this matter, this civil revision can be disposed. Yes.
the learned council appearing on behalf of the petitioner submits the instant matter is connected with the civil revision. Which one? Connected with civil revision number 14 of the 2023. 14, na?
My lord.
Earlier matter was 14.
I cannot remember. I think so.
You have a list. Hey, just give him the list. I think that is it. 14.
My lord, yes, 14 is different and this 12 is different.
No, which matter?
I'm talking about
one matter tomorrow. Which one is that?
I think number 9 is fixed on this thing for tomorrow. Yes.
9.
So this matter also, let it be taken up tomorrow.
That is why criminal civil revision 14
Yes.
is your matter, na?
My lord.
The learned counsel appearing on behalf of the petitioner submits that the instant matter is connected with civil revision number 12.
It's not connected, but it's similar in nature. Similar in nature.
Is similar in nature with civil revision number 14 of 2023. It therefore submits that as this court is fixing civil revision number 14 of 2023 tomorrow, the instant matter also be listed tomorrow. Taking into account the above, list the instant matter along with civil revision number 14 of 2023 tomorrow.
Minor. Right.
Orders, item number 13.
May I please, your lordship? Lordship, I'm appearing for Mr. Bendangwapang for the petitioner. Lordship, by order dated 7/5/2024. The petitioner was instructed to serve notice to the respondent one by registered AD and Dusty Service.
The service upon the respondent number 1 is not complete, as would be seen from the office note dated 22/5/2024. The applicant herein is directed to take fresh steps at the proper address of the respondent number 1.
Lordship, we have served copies through registered post. However, for registered post, we have served, but through Dusty, it's still.
He is not there. Department of Veterinary and Email. How can you send it to him? Find it out from them where this Mr. R. Enzung is. 10 days time is therefore granted to the applicant to verify and then takes appropriate steps as against the respondent.
Obliged, Lordship.
It's not a problem, you just find it out.
Lordship, obliged.
Orders, item number 14.
Made previous, your lordship.
Yes, Mr.
My lord, here, my lord, we had taken steps twice, my lord, but the addressee was not found in that address. And then, my lord, as per direction of this court, on 25/2024, we had given a paper publication as well, my lord, specifying the date fixed by this court. That affidavit is also brought on record, my lord.
What are you challenging?
Yes, my lord. My lord, we are challenging an FIR, which in my limited understanding, my lord, is out and out a breach of contract. Even if the FIR is assumed to be true on its face value, my lord, it does not disclose an offense of 406 and 420, my lord.
What does disclose?
If I may kindly, my lord,
No, Mr.
if I may kindly take, yes.
What does it disclose?
My lord, in my understanding, my lord, it does not disclose any cognizable offense, my lord. My lord, may kindly come to the FIR, which your lordship will find at page number 13. My lord, may I read the FIR, my lord?
Yes.
My lord, with reference to the subject cited above, I have the honor to report herewith for your necessary action, please, that sometime in November, December 2019, I approached C. So-and-so Ponjan to sanction a loan only to my wife, Srimati Rumi Shaha and Tinku Shutradhar. My lord, Tinku Shutradhar is the petitioner before your lordship, for a business purpose to run a garment business at so-and-so Dimapur. As such, basing on my request and trust towards me, an agent, Sri Shahib Yadav, who introduced us to Sri Ponjan and also who stood as a witness, Sri such and such had arranged the said loan amount of rupees 58 lakh only in between a period of 3 years to the borrower, Srimati Rumi Shaha and Tinku Shutradhar, which was given on installment basis through bank transactions, check, and some amount by cash. Thereafter, again, an amount of 3 lakh only was also sanctioned by cash in hand without proper documentation. However, despite of several reminders and lapse of over 3 years, the borrowers failed to repay the entire loan amount and rather kept on renewing the loan agreement on 3 occasions. And on 14/2/2022, a loan agreement was executed between the lender and the borrower, wherein the terms of the loan was extended further for a period of 7 months, commencing from the date of the said loan agreement, which have been acknowledged by signing in the said loan agreement by the borrower. However, it was learned that Sri such and such, that is the petitioner, along with his family members, has fled from Burma Camp Dimapur without repaying the loan amount, and their mobile phone has been switched off. Despite of several attempts, Sri such and such could not be traced. That the above act of commission and omission of so-and-so clearly implies that he had the intention of not repaying the said amount, and thus my wife, Rumi Shaha, will be liable to repay the entire loan amount alone. Therefore, being a law-abiding citizen, and since my wife has a health complication and also I am being one of the witness, I hereby report this matter before your authority on my wife's behalf and act on her behalf till the matter is solved. And further, I request your esteemed authority to initiate necessary legal action in order to repay the entire loan amount to the lender after the said such and such has been traced.
So,
now, my lord,
his wife
yes,
and this you
yes,
granted a loan at the request of the husband of at the request of the complainant.
the complainant, absolutely.
The petition,
now, my lord,
as the husband as well as the wife were given a loan of 58 lakhs at the request of the complainant. Now you are nowhere to be found. And his wife now would be liable to pay. That's the allegation.
That is the allegation. Now, interestingly, my lord, I am there, but the informant is nowhere to be found. Now, my lord, will kindly see the loan agreement which was annexed along with the this FIR, my lord, at page number 14.
Okay. And that is okay. Now what has happened? You want the quashing?
Yes, my lord, because my lord, this will not entail section neither 406 or 420. Now, my
Now,
lord,
what come out in the investigation? What
my
has come out in the investigation? Because the charge sheet has been filed.
Absolutely, my lord.
Anyway, Mr. Biswas.
Yes.
Today we have to deem the service to be complete.
My lord.
I can't quash the FIR today. Would it be proper?
My lord, my only humble submission, today would be if your lordship kindly sees the order which was passed on the motion date. This honorable court observed that on receipt of the LCR, at least my interim prayer will be considered, my lord. Your lordship may fix any date for hearing, at least because, my lord, prima facie I can demonstrate 406 and 420 are mutually destructive section. The ingredient of one will negate the ingredient of the other. If it is a 406, it cannot be 420, and if it is a 420, it cannot be 406. Prima facie wrong charges were framed. This is one. Number two is that, my lord,
But
there
that,
are umpteen
that
number.
may amount to, would that amount to the criminal court not framing appropriate charge?
My lord, I'll try to address to that, my lord. There are umpteen number of judgment of
2 o'clock.
My lord.
2 o'clock.
Absolutely, my lord.
Yes.
नाही.
So, ABC. That's what that. See, the people come to you. The people come to you. Send me the end of this day. Putting server. Yes. See, right? We do that. See, see, we do. Just when the joke that I use enough, just when the joke that I give enough. That's it, so, I mean, like, something like, you can do that, with what, and you need to be good. With the other, and that, kind of work. Put up what I said, we need some help. Don't want to see it. What is good? There's no technical.
Yes.
Please, Your Lordship. Lordship, kindly allow me to mention item number 16. I'm for respondent number 3, Lordship.
16.
Yes, Lordship.
Wait,
Lordship.
wait, wait. We are in the midst of a matter. Yes.
Yes. My lord. So therefore, my lord, what we have seen from the FIR is that the apprehension of the informant is that his wife alone might have to repay the loan, my lord. That is his apprehension against 420 and 406 has been inserted, my lord. Now, my lord, if I may just briefly touch upon 406 and 420 for a while, my lord, just for the purpose of an interim order, my lord. My lord, 406 is an offense for criminal breach of trust, which is defined under 405. Now, my lord, in 405, for the offense of 405 to come into play, my lord, there has to be an entrustment of property which is valid and lawful. And thereafter, my lord, the person on whom the property is so entrusted, he misappropriates the same and converts it to his own use. An example would be, my lord, a trustee or a executor of a will or people who collect tolls in the toll gate, my lord. If they converts and misappropriates it for their own use, then 405 would come, my lord, and punishable under 406. The allegation prima facie, my lord, prima facie, not even remotely touches upon the offense of 405, which is punishable under 406, my lord.
Then
coming to 420, my lord, for an offense of to constitute an offense under 420 of the IPC, my lord, there has to be an initial deception by deceiving, by playing fraud dishonestly. If I induce somebody to deliver a property, and because of that inducement, if he delivers that property to me, then 420 will come, my lord. It is a species of 415 that defines cheating. So, my lord, here is a case where the informant says that we had taken loan jointly. And interestingly, one more fact, my lord, the charge sheeted accused is only me, not his wife. So what he has brilliantly done is that he has saddened the entire liability on me, filed an FIR, and he vanishes. Now, my lord, here is a case where admittedly he has not paid anything to the petitioner. His only apprehension is this, that he apprehends that his wife might have to pay the entire amount. My lord, can this be an offense, my lord, subject to correction, my lord, under 405, 420 or any section in the Indian Penal Code, my lord? In my limited understanding, my lord, perhaps not. and the agreement, my lord, which was executed, page number 14, I make in special, my lord, I make in specific averment that this was made by force in 2020. Now here also in this agreement, my lord will see, there is no reference of any previous agreement. Within a period of 7 months, 55 lakhs has to be refunded. That is also absurd in some sense, my lord. Why I am saying it, my lord, your lordship is well aware, my lord, absurdity is also one of the ground under Bhajan Lal. 7 months, somebody is paying 55 lakhs and there is no mention how, when, in what manner, in installment over a period of 3 months. As vague as it can get, my lord. The charge sheet which they filed, the charge sheet does not accompany a single bank statement. It does not accompany a single agreement, because they say there were agreements from 2019 which was renewed and finally culminated into 2022 agreement.
So now you want to stay the trial?
My lord, yes, my lord. Because, my lord, prima facie, my lord, this criminal proceeding is an abuse of the process of law in as much as, my lord, the order of framing charge, your lordship will kindly see for a while, my lord.
Charge has been framed.
Charge has been framed. I have challenged that also. Page 30, my lord will see. No discussion at all. Page 30, my lord will see.
Why didn't you get a order on that date? Earlier date?
My lord, on that day, my lord, that day, the charge frame day, my lord. My lord will see page 30. On due consideration of the submission of the charge sheet file, it is the opinion of this court that there are sufficient material of 420 and 406. But how absurd this order is, your lordship will kindly appreciate. In 420, the initial entrustment is by means of deception and fraud. In 406, the initial entrustment is valid. And the judge can understand.
Are you admitting, Mr. Viswas, are you admitting that either of 406 or 420 can be applicable?
My lord,
that's
my
mission. There is a judgment of Ansari at that point.
Mahindra.
6 and 420 cannot go. That's on the basis of Supreme Court judgment. I understand that. Both cannot go together. There's no quarrel with that. But one can go.
My lord, my point is this, my lord. When I say, my lord, 420 and 406 cannot go together, the point that this council is trying to bring home respectfully is this, my lord, that the police, the trial judge, everyone is confused as to what offense is made out. So there, my lord, they're tossing up sections that one of the, my lord, they can come up with the entire IPC for that matter. That shows the level of confusion both in the mind of the investigating officer as well as the trial court as to what offense actually is made out.
So are you suggesting that you need to give some advice to these people as to give them that how one should frame charges?
My lord, that is there in Justice Ansari's judgment, which your lordship is indicating that Mahindra Finance judgment. My lord, even I was supposed to rely on that judgment as well to show that the ingredients of neither 405 nor 420 is present in this in this FIR for that matter. My
you say here, on the face of it, there is no case.
Yes.
No case. The case is no case. It's at best a civil dispute. A loan was taken that he and his wife, the petitioner and the petitioner here and the wife of the complainant took a loan, and the loan was taken in such a manner that the petitioner now is not to be found, And as such, the respondent out there, the case of the complainant is what will happen to my wife? Wife has not come up. What will happen to her? But the complainant says, what will happen to my wife? I've tried to call him
Lender has
up.
also not come up. Lender has also not come up.
Huh?
Lender has also not come up.
That is what I'm asking her. So it is not the case of even the lender, the loanee, that is, the petitioner hearing is not responding to my calls, nothing. And on the basis that the husband of the wife of the accused said that okay, we are going to make the payment. 406 and 420 is done. This is a case of washing. Pure and simple, a case of washing. Now, service has been meted out. They are residents of Dimapur.
Yes, that is, my lord, what appears from their FIR and everything. We have taken service. Even to leading newspaper in the state of Nagaland, we have given paper publication. He is not turning up, my lord.
Is it out of that 55 lakhs you have taken, you are spending on the paper publication?
Well, that's too big an amount for paper publication, but at the same time, my lord, paper publication is a costly affair, I understood recently.
Chalo, I heard Mr. M. Biswas, the learned counsel, appearing on behalf of the petitioner. Ms. M. Mary, S. Mary, the learned counsel appears, the learned PP, the learned PP appears for the state. None appears on behalf of the respondent number 2. It is noticed that by an order dated 25/2024, this court directed the petitioner hearing to take steps by way of paper publication. And in accordance therewith, paper publication was taken on 4th of June 2024 in Nagaland Post as well as in Morung Express. Where? You must have given it in such a small manner that nobody could see it. Where is it?
Page 4. Page 4.
4. Okay. This court have duly seen the said paper publication and accordingly deems that the service upon the respondents, number 2, is duly complete. Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner, further submits that further drawing the attention of this court to the order dated 15/3/2024, submits that the petitioner, that this court may take up the prayer for interim relief, which have been sought for in the instant application. First, the learned counsel submits that submits drawing the reference to drawing the attention of this court to the FIR, the charge sheet, as well as the order passed by the learned court of the judicial magistrate first class on 14/8/2023, that the dispute involved herein is purely a civil dispute, and as such, no case is made out in terms with section 406 or 420 of the Indian Penal Code. First, this court have duly heard the learned counsel as well as the learned PP. And from a perusal of the materials on record, it transpired that the dispute prima facie appears to be a civil dispute. And the ingredients of section 420 and 406 and 420 of the Indian Penal Code is absent. Under such circumstances, this court stays the further proceedings of GR case number 488/2022 in connection with East PS number 158/2022 before the Court of the Judicial Magistrate First Class till disposal of the instant proceedings. It's the
My lord will
matter
add-
on when? Tomorrow?
No, my lord will add Judicial Magistrate First Class Dimapur.
Dimapur.
My lord, after vacation.
Tomorrow?
After vacation, my lord. Let the monsoon subside, my lord. We may physically come, my lord.
Here the vacation starts later. Here the vacation starts on 12th of July and finishes sometime in 21st. You want it on 22nd? Place the matter on 23rd of July 2024 for hearing.
I'm deeply obliged, my lord.
For orders, item number 15.
May I please, Your Lordship? Lordship, in this matter, service upon respondent number 2 is awaited, Lordship.
Notice issued upon respondent by registry on so and so. Return email. From a perusal of the office note dated 5/6/2024, it reveals that the service upon the respondent number 2 was issued only on 3/6/2024. Taking into account the above, this court would await service upon the respondent number 2. List the matter after 4 weeks.
May I pay for fixing a date, Lordship?
What?
May I pay for fixing a date, Lordship?
Why?
We are outstation counsel, Lordship.
Last time also it was 4 weeks. And then that court did not hear, and now you want this court to fix it.
It's difficult for us if there is no date.
Huh?
May I pay for fixing a date on 25th of July, Lordship?
This is the matter on 26th of July 2025.
25th.
25th of July 2025.
Much of it.
For hearing,
The
item number
registry
16.
shall put an up, and the registry shall put an update as regards the service upon respondent 2. Yes, you were all worried. 16.
Yes, Lordship.
You are
Lordship,
for?
I'm for respondent number 3, Lordship.
Then?
Lordship, I was informed that the counsel for the appellant, he's in Allahabad for the last ritual of their dead father.
Allahabad?
Yes, Lordship. Counsel for the appellant, as well as counsel for respondent number 1.
What is these affidavits, filing of so many affidavits out here now, appeal? This business of an appeal being converted into a writ petition. What is this?
As well as
What order is this? An appeal is being filed against an order. What is that? Whether the is demands. You have got the money.
Lordship,
You got the money.
Respondent number 1, 2, and 4 is not present as well.
You are who?
I'm for respondent number 3. Counsel for respondent number 1, 2, and 4.
Who is the claimant? Claimant is who? Who are you appearing for?
Owner of the vehicle. I'm for the owner of the vehicle.
Who is the claimant is where?
Respondent number 1. Respondent number 1, 2, and.
And what about the service upon the claimant? Service completed?
Yes, Lordship.
Okay. Hello. None appears on behalf of the appellant on call. Full stop. For the ends of justice, the matter stands adjourned. Full stop. To be listed after 4 weeks. It is made clear that if the appellant is not represented on the next date, the instant appeal shall be dispersed for non-prosecution.
Pleasure.
For hearing, item number 17.
May I please, Your Lordship? I'm appearing on behalf of M. Solo, the counsel for respondent 2 and 3.
Who are you? 2 and 3 is who? Who is 2 and 3?
They are the insurer of the vehicle.
Lordship, I'm not the counsel of this matter.
Responding
I'm appearing.
are the insurers.
Who has filed the appeal?
I am the counsel for the appellant.
Understood. Who is it? You are the claimant.
I am appearing for the claimants.
Claimant.
Yes.
You are asking for enhancement, or is it the case of dismissal?
The direction was passed on a wrong finding.
Huh?
By the learned tribunal. A wrong finding.
How much amount did you get?
The total awarded amount is
Lekha is MAC 615. What has this court said decided? MAC 15. Now there shall pay an amount of rupees 30 to the claimants at a simple interest of 9% from the date of filing of the claim petition till the award is there. No interest shall accrue on the future prospects. Addition of 50% out of the awarded amount of rupees so and so be given to the wife of the deceased. Claimant number 1 is so and so. Yes, why are you challenging it?
my challenge. Kindly see the findings. It is in the Mbyong Judgment and Award. It is the page 33 of the internal records.
It's okay. Now tell me, what is the ground of challenge?
My challenge is that the deceased was held to be a courteous passenger in a court carrying vehicle. That is what the findings of the learned tribunal. However, it is not supported by any evidence. It is supported by the evidence to the contrary. That the deceased was the owner of courts, accompanying the courts carried in the vehicle. So the liability of the insurance company is covered by the amended Act of Section 147 of 1994 Amendment Act.
But you have been paid.
I have not been paid.
No, you have been paid. Are you not in MAC 15?
Yes, I am appearing for MAC 15.
Okay, so you are being paid.
But against that, it is directed against the wrong respondent. I am entitled for joint and severable liability against the respondent.
So it has been given against the owner.
Yes, it is
not the insurance company.
to the owner. Not insurance company was exonerated.
So your case is at best owner, insurance company, whoever it is.
Yes.
They should have directed the payment to be made by the insurance company.
Yes, definitely.
And may go for pay and recovery from the owner.
No, that is also not. Because their liabilities are
You are concerned with, Mr. Counsel, you are only concerned with your money. Mr. Counsel, you are only concerned with the money.
No, Lordship, kindly, I will
No, Mr. Counsel, kindly see. You are concerned with your money.
No, it is.
Are you filing the appeal on behalf of the owner?
I am entitled to recover the vehicle from the insurance company.
Understood, but the direction is to the owner.
That is why it is only given exclusively to the owner.
But owner is not before this court.
Owner is indemnified. I am entitled to realize the amount from the insurer. That is my case before the tribunal.
How is it concerned that you get it from the owner or the insurance company?
Since the owner has not challenged, I have completed it as a respondent.
Understood. Owner has not challenged this very well. No problem with that. But you may very well submit that, look here, the court should have directed the insurance company to make the payment and recovery. But you are not against the owner. The owner has not come up before this court.
No, my lord, my prayer before the learned tribunal is the liability of the owner was indemnified by the insurance policy. So I'm entitled to realize the compensation from all the respondents jointly and severally. That is my case.
Jointly and severally.
So I have never sought to recover the amount from the insurance company and to direct the company to recover the
amount. Who is appearing for the insurance company?
That is not my case.
Who is appearing for the insurance company?
Lordship.
You?
Yes.
What do you do? What do you have to say?
Lordship, I'm not the counsel.
No counsel.
I'm appearing on behalf of
the insurance company is not represented. Don't worry. We'll pass the order against
due to medical emergency, the counsel for respondent is not present today. He is out of station.
So what?
Due to medical emergency. So I was instructed to appear on his behalf.
Lordship, it is a fixed matter. I need allowed to be heard. Let the opposite party be heard in some other day.
I won't be here on some other day.
Lordship, let this matter be possible for a day.
For the day?
For a day.
I'm
For
also an outstation lawyer.
Very well. We have the facility out here of giving you the benefit out here with this video conferencing. I have understood your point. Your point is that you are not a gratuitous, your person was not a gratuitous passenger.
Yes.
And as such, he is entitled to get the money. But irrespective, Mr. Counsel, I make it very clear, irrespective of all these things, the question is, you are entitled to the amount. And the court should have directed the insurance company to pay and recover it from them.
That is in case terms of the policy has been violated.
Valid.
But here in this case, violation does not arise.
And that is for that owner to come. Forget about that. You are concerned with the money. You have to get the money from the insurance company. That's all. Would you be happy with that?
Of course, I'm jointly and severally entitled.
Understood. You want that 34 lakhs, you get it from the insurance company and let the insurance company recover it from that owner.
Lordship, that is only in case of violation of the terms of the policy.
Why?
But here, no terms and conditions of the
No, we are
policy has
not
been
concerned
violated.
to that effect. Because the insurance company is done, whether it is there or not, that is a different aspect of the matter. We are only concerned that you are entitled to the amount, that's all. How you get the money, that is, whether you get it from the owner or there, that is the question. Here the amount is not in question. Here is a question of whether it is the insurance company or anybody has to pay. So we direct the insurance company to pay and recover it from the owner. What's wrong?
Recovery question among the interested respondents, that is not my interest.
What? Are you appearing for the owner?
No, Lordship, it is only published in the newspaper.
Forget about
With
that.
this.
It appears that, Mr. Counsel, it appears that
Lordship,
it is an appeal through the claimant of the owner. I've never heard of you being interested. Is the color of the money of the owner and the insurance company different? The direction is to be that you are to get the money, you get it from the insurance company, and thereafter the insurance company let it recover from the owner. That should be the direction. How will we agree with that?
In the event, the owner comes and prefer before the Supreme Court, it will be my brother. That is the case. The claimant shall unnecessarily suffer. That is the case.
Let the owner do whatever, but the owner has not challenged this award. The owner has not challenged this award, so he cannot go to the Supreme Court. Why are you not understanding that? Anyways, better of you make some other judge understand about this thing. This is not the manner in which, because for me, it seems to be an appeal filed in the garb of to the owner, blaming the insurance company. Okay. Taking into account that the counsel for the respondent is not present, it's expressed difficulties, matter will be listed. When?
For a day, Lordship.
No, when?
Lordship, it need to be listed after 2 weeks.
Okay, list the matter after 2 weeks.
Let's go, Lordship.
For hearing item numbers 18 and 19.
Yes, Mr. Moju, why are repetitions before this court?
Lordship. I even may, since the matter has been listed, Lordship. A similar matter was heard, Lordship. Whether the judgment delivered by this Honorable Court, Lordship, in a similar matter. Because here the petitioners are appointed in the year 2010 and 13. There are 2 petitions, 2 badges. We were appointed by the government on post-creation of the government. Post-creation of the government. We have gone through the selection process, district selection process, district-wise.
we have been selected. Now, Lordship, fixing our seniority, we have approached this Honorable Court before. The court, in a similar matter, has laid down the judgment, Lordship, saying that seniority will be counted from the date of appointment, absorption in the service. So we filed a repetition, Lordship. On the submission of my learned friend, Lordship, the case was closed. Without going to the merit, it's a covered case. Now, our case was not considered because we are claiming our seniority. We are not asking for financial benefits, Lordship. Financial benefit, we are getting everything from the date of our appointment. But they have not included us in the seniority list. Now what has happened, Lordship? Government took a decision for encadrement of our service in the state service. A similar case was moved by Mr. Joshua Shiki, Lordship. Mr. Joshua Shiki has filed a similar matter. And this Honorable Court, Your Lordship, has already passed a judgment.
For what?
On the ground that my seniority will be counted from the date of the state government decision for encadrement. That is from 2022. I have been appointed way back in 2010 and 13. I've been serving all this well. They have even incorporated me in the seniority list. But because of some complaint from a group of teachers.
Oh, that long list, madam.
The long list, yes.
Your Lordship has dismissed those bunch of writ petition because the petitioner here in also they are appointed under the scheme RMSA and SSA.
Oh, this is RMSA?
Yes, RMSA and SSA. So they do not come under the state gather. Only in 2022 we have entered them. So they are asking for yes. So Your
Lordship, I haven't gone through the judgment, Lordship.
Please go through it. Because you see, this is based upon that Supreme Court judgment. There's a Supreme Court judgment which I have referred to. Anyways, you go through it whenever you feel like.
Lordship, now the issue.
Otherwise, it is covered because you are there in RMSA, because they. And there's a 98 or 99 matter. There's a judgment, no? Supreme Court or 2016, I forgot that day. It's a very short judgment. It's a one paragraph judgment. Interestingly, it's a long paragraph.
Lordship, yes.
Very long paragraph, but one paragraph.
2022
that is another. That is permanent, I suppose. Yeah? That is one.
Yes.
And there is another judgment, Daljit Singh or something.
Huh?
Yes. That is the 96 or
2002.
2002. So in those things, it says that the state may not have any money. You have a look at that. You have a copy of it?
No, Lordship, that part I have understood, Lordship. But here, the question of financial implication is not there. There is no question of financial implication.
No, it's not a question of financial implication. You were not brought within the cadre of the government. How can you be given a signature?
No, Lordship, as per the RTI filed by us, the state has admitted you are a state government employee. You are a state government employee, the RTI.
Understood, but the state saying like that, they would not do.
Now, Lordship.
They have brought in out here, kindly see, Dhyan Singh. Dhyan Singh is the judgment wherein it has been categorically observed. I put it Dhyan Singh somewhere. This is yes. Yes. Kindly come to page 166 of 173 of the judgment.
166, Lordship, yes.
The continuance public engagement of the appellants under the specific scheme cannot be held as an employment under any establishment of the government. Such schemes are taken up for certain contingencies when money for the same is provided either by the central government or at times by some foreign countries. But the employment under such scheme not being a part of the formal cadre of the state government, it is difficult to hold that the period for which an employee renders service under such scheme can be counted either for the purpose of deciding their pensionary benefits or even for fixing of their salary in the scale of pay once they are regularized. The judgment of this court pursuant to which the appellants were absorbed as against regular vacancies in the government itself would indicate the court had taken a compassionate view and not any right which flowed from the past service rendered by the appellants under so and so. We have not been shown any rules or regulations of the state which ever confers pensionary benefit to such services rendered by the appellant. In that view of the matter, it is difficult for us to find any infirmity with the impugned judgment of the High Court. We therefore see no merits in the appeal. Then in permission under, the question came as regards those people who were there working in the state of undivided state of Bihar. Then at paragraph number 21, kindly see page 168.
Lordship, if that's the case, now we have challenged in the first writ petition those contract employees who were regularized after us, giving their seniority from the date of the initial contract appointment. We have challenged that in the first writ petition. Now, state respondent is saying, in view of the judgment passed by this honorable court, Lordship, even the division bench has upheld, saying
This
that
one, upheld.
no, not this one, Lordship. I have annex. Lordship, I kindly come to page. It's a very bulky petition, Lordship. In WPC number 214, page 84. This case was decided, Lordship.
Which one?
Page 84.
279 WPC?
No, 214. Lordship, I'm referring to 278 WPC.
278.
278, yes. Since this was filed first, Lordship, so I'm referring to the first writ petition.
Page?
84.
84.
Yes.
Yes.
This is a different matter.
No. Lordship, the state respondent has admitted that this covers my case.
Where is it?
The state. No.
Where is the order?
Lordship, 84, Lordship, page 84.
84 starts.
And actually,
where is the respect?
Yes, the operative portion, Lordship, may kindly come to page number 192, page 192, paragraph 24, Lordship, as well.
Have issued the finance seniority of GT by the year in the state seniority of the private respondents so and so were all placed below the remand in so and so. The seniority list was never put to challenge and was allowed to retain finally. It was therefore that Anstar has filed a RIA which was registered as so and so. The seniority was disposed of by this order dated demand directing the concerned to consider the representation submitted by petitioner therein.
Lordship, paragraph 26, Lordship, next page 193. Whether the government of Nagaland
dated demand whereby it is the consistent policy that the seniority of the contract will be counted from the day on which they have been absorbed on regular basis.
The action of the state respondent while issuing the GT seniority list is in violation of those memorandum and the letter of the government of Nagaland. In the facts and circumstances what has been discussed here and above, the writ petition so has been made case and accordingly impugned.
So here also it says that it has to be from the date they are regularly absorbed.
Yes. Now, Lordship, this is a different case, not by us. We have filed a writ petition challenging those contract employees who were appointed after us. Now the government
contract of what?
Teachers, graduate teachers.
Not under the schemes.
State, under the state.
That is a different aspect again.
Yes. They were
if they were ad hoc appointees.
Yes.
Then in view of the direct recruits judgment, within they come, the seniority would be taken in view of section 4, paragraph 47A.
Yes. Now, what has happened, Lordship, in the writ petition filed by us? We filed a writ petition challenging their regularization from the date of the initial appointment. What the government has done is, they were appointed way back in 2000, but they have given, they were regularized after 2010 onwards, Lordship. But their regularization was with effect from the date of the initial appointment. We have challenged. Now, in view of this judgment, Lordship, my writ petition was closed, saying that this covers my case. Lordship, may kindly come to my judgment, my order, Annexure K, page 195. There were 3 writ petitions, Lordship. 122K of 2017, writ petition 170K of 2017, and writ petition number 172K of 2017. These are the 3 analogous writ petitions filed by us, Lordship. Now, Lordship, may kindly come to the order. 1/11/2017.
Page?
Page 195.
Yes, I've seen it.
Yes. It is a consensus of the legal consensus of parties that the present writ petitioners are covered by the judgment on order dated 1/9/2017. This, the one that I've referred to. Passed in the by this court in WPC number 34K of 2016. In that view of the matter, all these writ petitions are disposed of with the direction that this case which shall be covered by the judgment on order dated 1/9/2017 passed in the WPC number so.
So what are you challenging in 278?
Lordship.
What are you challenging?
Not including us in the seniority list.
With that of?
The regular employee, because there are
No, regular employees it cannot be.
Yes, that's why your lordship.
You cannot have with the regular employees. Covered?
Yes. It's clearly covered, your lordship. Your lordship judgment is clearly covered the present case.
What happened? No appeal filed?
No.
Lordship, I agree with you, Lordship, yes. But the fact remains, Lordship, yes. Lordship has referred to the Dan Chand case, which it speaks about they were in the scheme. The government has never, in their affidavit, stated I was appointed under the scheme.
Huh?
I was appointed under the scheme. They have never stated. Merely
your appointment order shows that.
Against
RMSA.
Against post creation. Against post creation.
You were RMSA.
RMSA, yes.
So you were regularized on 21/4/2022 pursuant to the cabinet decision. And what does the government have to say? This is covered. Unhelp it.
Lordship.
You may try your luck in some other court. If this court is bound by this.
Yes, if I may be allowed, Lordship. If I may give a try in the other court.
Lordship, even if it tries also,
yes,
he
Lordship.
cannot stand. So your lordship, instead of keeping painting, your lordship may decide on this matter. Because
the bar is not liking that I am disposing of matters. I've been told, even the registry says that if I keep on disposing, what will happen? That the state of Nagaland would never have a high court.
So your lordship, it's very clear. The record speaks that they are appointed as
yes, it is covered. There's no quarrel with
my
that.
prayer is that instead of keeping pending, your lordship may dispose of the matter. Yes.
These type of things should be kept on record.
Definitely, they are going to rely on your judgment, Lordship.
No, if there's no appeal has been filed out there, you see, otherwise the problem arises in view of this permission.
Lordship.
That is the squarely covered aspect of the matter. Then Permission Nanda was a case where in the state of Bihar,
Lordship,
these people were earlier in the state of Bihar. Then they came over to the state of Jharkhand. Then at that point of time, when they were in the state of Jharkhand, they were appointed as like some other officers out there, and they were said that, okay, they will be brought in, but they would not be given some seniority in terms with some office memorandum out there.
Lordship.
Then they came up and challenged out there. So relying on this, paragraph number 21 of that judge, kindly come here, 21. What does it say? Can we see here? The appellants were appointed, paragraph 21, page 168.
Lordship.
The appellants were appointed under a specific scheme.
Lordship.
That is the project. Such project was not a permanent establishment of the government, as it was meant for a specific purpose funded by the central government for a specified period.
Lordship.
The appointment of the appellant under the project is not a part of the cadre of the state government. Therefore, the first condition of Rule 58 that the service rendered must be under the state government is not satisfied by the appellants having been appointed under the project. The second condition is the employment must be substantive and permanent is again not satisfied by the appellant as the employment of the appellant was not under the project. A permanent post in terms with Rule 31 means a post carrying a definite rate of pay, and that is sanctioned within a time limit, without time limit. The appointment of the appellants under the project was not in a pay scale, or nor was it a sanction within a time limit. Further, the substantive pay is defined in Rule 38 of the rules as so and so. If the first and the second conditions mentioned in Rule 58 is not satisfied, the state government can declare any kind of service rendered in non-capacity, gazetted capacity to qualify the pension. The circular dated deals with pensionary benefits to a temporary government servant. The appellants were never appointed by the government either on a temporary or on a permanent basis. The appellants were engaged under the project that is a scheme, therefore, the benefit of a circular cannot be claimed by Still further, rule so and so empowers to declare any kind of service to qualify for pension. The notification for absorption circular is so and so, so and so. The policy contemplates that it is the fresh appointment and no benefit either of the seniority or pay protection shall be given. The appellants have not disputed such a condition of appointment having been appointed under such policy decision by the notification dated so and so. The circular has not granted pensionary benefits. In absence of any specific condition in the circular to grant pensionary, it is not possible to read the pensionary. Cannot turn around and so and so. One aspect is very clear that the engagement of an employer under a specific cannot be held to be an employment under the establishment of, inasmuch as employment under such schemes cannot be treated to be a part of the formal cadre of the government. In the case of so and so, this is another case, Mahapatra. Yeah, so and so, he has validated and such the legislation of given. Judgment in Shiraz and direct reward are of the proposal once an incumbent is appointed to a post according to the rule, his seniority has to be counted from the date of his appointment, not according to the date of his confirmation. However, the period was appointed against a scheme which was not a part belong so and so. So, don't have a case.
Lordship, if that's the case, Lordship, going by the advertisement, Lordship, though we have been specifically for the...
You can do one thing.
Lordship.
Can he resign and go back to RMSA?
Lordship?
Can he resign and go back to RMSA?
He is challenging the government order and considering them. So, Your Lordship, once it is up to the petition.
We do one thing.
Yes.
We set aside the cabinet's memorandum
Then he
insofar as the petitioner is concerned.
Exactly. Lordship.
Would you like that?
Yes.
In RMSA.
That's what, Lordship. He's challenging that one.
You can't do that.
Not disputing to that fact.
Something the government has done to include you. Now you are asking for that.
Seniority, yes.
Because my appointment was on the basis of a post creation with scale.
You were, whatever may be, post creation, that was to be done in view of the RMSA, which was required that you have to create a post because the funds has to come against the post. The central government, where will they give? But then also your appointment were contractual.
Lordship.
This was not a period for all time. It was contractual appointment.
Those who were appointed after us, 15, 16 batch, their pay was fixed by the government of India. Fixed by the government of India. Primary teacher, 25,000 and likewise GT more. But our case was a bit different, Lordship.
But did the government of Nagaland pay the amount? Did the government of Nagaland pay the amount? No, the payment has all along come from the central government.
We have been receiving MSCPs. MSCP also have been granted to that.
Understood. That was also duly taken care of. MSCP you have been given out there, then also it was goodness of the state. In fact, they could not have been. Tell me, how can there be an MSCP when there is no concept of a promotion? It is only a stagnation of a promotion which allows MSCP. But not in a case where there is no promotion. If you are a graduate teacher, you are going to remain a graduate teacher. There is nothing which is given in at any point of time that you are going to get anything. Yes. One thing which was relevant, which I put a question to her is, in terms with the RTE rules, RTE Act, have they framed any rules which permits granting of certain benefits which are there in terms of Section 21? That is another aspect of it. But you are not there. Now you are in the government. You are going to get it. Okay. What to do?
Lordship, I leave it to you, Lordship.
Same. You were appointed in which batch?
Lordship, may kindly come to page. 37. Page 37, Lordship. The type copy at page 38. 2010. May 2010.
You are selling the notifications, which one?
The government notifications, Lordship.
I would not like you to be.
If this lordship is question set aside, then they will return back to be an RMSA and SSA one day.
Lordship, we are not challenging the entire notification. We are seeking for modification of certain notifications, Lordship. The cabinet decision to encadre us with effect from 21/4/2022. Lordship, that will found, Lordship, the 2nd of September 2022. 2nd of September to Lordship, Lordship. 2nd September.
In that case, they sell 29. Now,
Yes.
you have now sold another one, 21/4 also.
21/4 also, Lordship.
Impugned cabinet memorandum approving the proposal for mainstreaming SSA and RMSA batches in the school in so far as it relates to the instant petitioner. What is this?
Lordship. My prayer, Lordship.
And what is 27/9/2022?
27/9/2000.
Non-inclusion of teachers in the seniority list appointed after 22/9 classification. Directing the state respondents to comply and implement the High Court's order.
6. Clause number 6. Clause number 6.
Clause number 6. Where is that?
Page 284, Lordship. Teachers appointed, recruited after 2009 shall be incorporated in the seniority list only after clarification, rectification of duties, verification of claim. This phase-wise issue of graduate teachers seniority list has been page 284, Annexure S, in WPC number 278, Lordship. By this notification, they have directed, the government has directed the department not to put anybody who has been appointed after 2009 into the seniority list. So we appointed in 2010.
We see the serial number 6. This seniority is maintained for those people who are appointed prior to 2009. And after 2009, we are under process as per the court's direction, Your Lordship.
So here it says teachers appointed, recruited after 2009 shall be incorporated in the seniority list only after clarification, rectification of the dates, verification of claims. This phase-wise issue of graduate teacher has been necessitated to expedite the process of finalization as per the direction of the Honorable Court and to enable and effect promotion to the eligible senior graduate teachers.
Yes, Your Lordship, please.
So this clause doesn't seem to be wrong. What is wrong with this?
Because we will not include it in the seniority list. That's how we've been.
How can you be included? You only came into the state cadre in 2022. So other consequential challenges to 21/4 and 27/9 is dependent on 2/9.
Yes. Yes.
If 2/9 is okay, the other two becomes useless. Isn't it, Mr.? Justice Jameen told me you are still sitting. You got 20 matters, you are still sitting.
In fact, all the lawyers were here. The court one was empty.
You were appointed in the 2009 one or 2010?
2010. WPC number 278 is the 2010 batch and 279 is the 2013 batch.
We do one thing.
Lordship.
Instead of your petition, your order being similar to what or similar treatment being given. Where is that order of Justice Amin?
Lordship, page
270.
Page number 195, Lordship.
Instead of me passing an order like this, I pass a similar order like this, which have been passed earlier.
Lordship.
So that you can challenge it.
Lordship.
And your client will also have the satisfaction of having a longer order.
Lordship.
Yes, madam. It is the judgment that I say more dear about WPC 229/2022. The judgment was delivered on 27/2/2024. Itu eke hobo, naam change hobo, agote M Mojo hobo itu, and she is the same. For this one being a common judgment, upward by common judgment and taking into instant batch of repetition, only the instant 2 repetitions are taken up. The petitioner has said that notification to the limited where the seniority of year so and so. How to sort paragraph 3 arata lekhibo. In addition to that, the petitioners have also said the cabinet memorandum dated 21/4/2022. And in addition to that, the petitioner you are here also. It is the same challenge is there.
Same.
Then here. You can get to 145 between the so. They were coming now, they come that and so 21 for them. They brought it in the arbitrary out the effect from 24. Yeah. Yet page paragraph 11 not put Mr. M. Mojo's name instead of Joshua Seki. That is his submission. They submitted, and these are the judgments. You rely on the same judgment. And madam's name is there, paragraph 14. It is her submission, made a query upon these things, so and so, so and so. Aforementioned to Iman, additionally, in a representing Iman. Last year, so and so. The judgment in James is so and so. The prisoner therein was reputed, so and so. In the ban, let this court take into consideration the referred by so and so. Now coming back, the weapon created in the post of so and so. The consequential effect of the said opinion in the petitioner in the say has to be counted on the basis of the said notification that they imported the implementation cannot interfere with. The way of granting of financial obligation not be here according to buried in this reputation. To subscribe to the pension scheme, taking into account the submissions of the new. No. Here you are getting pension.
Lordship, that as per the RTI, since we are regular government employee, they have already admitted that I'll get pension. I'll get pension, Lordship. Because in the RTI reply, Lordship will kindly appreciate page 77, Lordship. In our RTI reply.
No, only one thing. Here, would you say I submitted that not only the office of the Imam is treated in the regular cadre of the year, but also even the Learning Council is submitted. Consent to the said notification has been brought on the Grand Imam and we reply Imam. Amen. Yeah. Did you, in paragraph number 11 of the said judgment, have a look. Page 1. The fifth line in the said judgment of paragraph 11, fifth line. He further submitted.
From below, Lordship.
And the fifth or below, yeah. He further submitted. Do you get it in page paragraph 11? He further submitted that the respondent authority all along had treated the petitioners as belonging to the regular cadre of the government, never taking into account that the petitioners were allowed to subscribe to the pension. And also some of the petitioners have been granted the modified year. Is it your submission also to that effect?
Lordship, I've not stated this, but I have RTI reply.
Is it your submission? Can we take that as your submission?
Yes, it can be also.
Because they
I'm saying I'm appointed on a regular basis. So there.
No.
Yes.
Kindly come therefore to the last paragraph of the judgment, page 29, paragraph 29.
Paragraph 29.
Because this I protected you.
Yes, sir.
Before parting with this court, however, finds it relevant to clarify and observe that the respondent state, if under mistaken belief had permitted the petitioners to subscribe to the pension scheme and taking into account the submission of so-and-so, that the benefits which have accrued by subscribing there would not be disturbed. This court leaves it to the wisdom of the being the welfare state. We put this like this. Shall do on this process.
Because even my retirement will be counted from the date of 2010.
Therefore, your submission is that you were earlier enrolled as a pension scheme. Her submission is that if they have been, we are not going to disturb.
Yes.
So I therefore leave it to the best we are, taking into account that it is the stand of the state that they are not.
Yes.
So it will be, you will be, then if they are counted from there, the basis, because pension is not allowed in SSA.
Yes.
Or RMS.
It's a court term.
But they have permitted you.
Yes.
And she said that she would not be disturbed.
Yes. Because it was a specific reply from the government that I am a state cadre. I'm not under the SSA. Post-creation has been done by the government and not SSA or RMSA. Specifically in the RTI. And that was...
No, understood.
Yes.
If you see in my judgment, I have recorded how the posts have been created.
Yes.
In fact, all these things have been quoted.
Yes.
How the posts have been created. That is why I'm giving the satisfaction that it won't be a judgment like 195.
Because my past service as under RMSA will be counted for my pension.
No, they say that they won't disturb.
Yes.
I never said that.
Yes.
I said that they are not going to disturb. Okay then.
Obliged.
But the would not like it, huh? The bar. Yes. The bar would not like it, disposal in this manner.
Lordship, for me, I had maximum disposal last week. At least my day, all day spent in the court was not in vain, I should say.
For me also, I want to dispose of my matter, Your Lordship.
See, the thing is like this.
Lordship.
If a person gets relief, when a petitioner gets a relief, it is against the respondent.
Exactly.
If the respondent gets a relief, it is against the petitioner, but a relief is given to either of it.
Yes.
One.
There cannot be two winners, Lordship.
The thing is, however, if the matter gets stagnant,
that's it.
People lose hope in the judiciary.
Exactly. In fact, Lordship has not to outside the court, Lordship. Disposed so many matters like which have been pending since 2018-19. No disposal. Because it becomes a question of a frustration for us also, Lordship, as a lawyer also.
Yes. And you see, people they don't understand.
True.
Say that my matter is there, the lawyer is not in a position to dispose it of.
Yes.
So they either lose the faith in the system.
Exactly.
So somebody told me that if you dispose so much, what will happen to the state of Nagaland? The only thing is happening is that people will come more.
In
fact,
they
will get something is done.
In fact, on Wednesday division bench,
yes,
I attended the first item till the last.
Yeah.
I was literally exhausted that day, Lordship.
No, no, because that entire series of the PI,
Very true.
I
Very
could have finished it off on that day, the long series.
The long
I
series,
could have
yes.
finished off every time the matter is coming out.
Yes.
It is nothing out there. The petitioner has nothing. He can't say anything to that effect.
Yes.
But however, one chance it's given. Affidavit was not.
Specifically,
You said
yes.
something else in that
Yes.
affidavit. So once that verification is done, next day the court can finish it off.
In fact, the petitioner was saying they were satisfied. But in the due course, since the lordship has pointed out that in the
So
affidavit,
let them
that's-
be
yes.
one thing. Once it is, I think these matters can be finished off.
Yes. In fact, those PIL was an eye-opening for the department also. Honestly, lordship, because we could cross-check the officials, the doctors, because there are many issues. They never go to the place of posting. But because of
Just for that JSSK scheme.
yes, lordship.
You see, the JSSK scheme was never conceived of that there will be any problem with the this what do you call the pregnant woman or the newborn sick child. They will be given all benefits.
Yes.
It is only that some benefits they may not like for food.
Yes.
They don't like the food of the hospital,
Hospitals,
so
yes.
you pay them the money.
Yes, yes.
They may not. Just a person staying in some nook and corner may not or may like to come on a particular date when the ambulance may not be available. So you pay him them that.
Yes.
But other benefits you are all giving.
Yes.
So there was no point. It was only a clarification.
Yes, lordship. In fact.
The JSSK regime for that matter was pending from 2019.
Yes, lordship.
So it was only a clarification necessary that they are entitled to all three.
Yes.
I have put it out there.
Yes.
That it is that food and aid is also optional.
Optional.
These persons may very well say that, okay, I need the food, you have to give them a food to that. But you can't give them the 350 rupees to that effect.
Yes.
Because that is the scheme. But it is for their benefit, the state is saying that, okay, we pay you this amount.
Yes. No, in fact, most of the beneficiaries, lordship, that's just a discussion. They need money. So, actually, the government of India has given the scheme, it should be direct benefit transfer, DBT. But most of the villages, they don't have an account. So, if they come to AVL also, we cannot forego the government of India direction. There have been a lot of audit reports against us. Why are you giving in cash? So we have given justification. A villager, poor villager, to open up an account, he spent thousands of rupees. You go to the town, open an account. To get a benefit of 600-700. So looking into those, we give them cash also many times. But now, because of the complaint being made and then PILs being filed, now we have said no, nothing doing, we are going to do. Unfortunately,
better.
Yes.
This is better because you see, then there is a more of a direct benefit.
More transparency also.
More transparency that you get this is it. If you don't like the food, then it is your lookout.
Yes. Under the PFMS format lordship. It's going to the government of India. So
You may have file another PIL for the purpose that the food is not good. That is another.
True, lordship.
Okay.
Obliged, Lord. I mean, retirement dia tu na 2010 lah account tu.
Apa ni